All rise.
Kosovo Specialist Chambers is now in session.
Please be seated. Good morning. Madam Court Officer, could you please call the case?
Good morning, Your Honours. This is case KSC-BC 2020-05, the Specialist Prosecutor versus Salih, Mustafa.
Thank you. First, I will call the appearances. Let me see. Could you tell us who's present for the Specialist Prosecutor's Office, Mr. Prosecutor?
Yes. Good morning, Your Honours. Good morning, everyone in and outside of this courtroom. Today, the prosecution is represented by Mr. Jack Smith, Specialist Prosecutor, prosecutors Silvia Dascoli and Filippo De Minicis. We also have with us the case manager, Julie Mann, and I'm Cezary Michalczuk, the SPO prosecutor.
Thank you. Victims' Counsel, you have the floor.
Good morning, Your Honours. Good morning, everybody. Like yesterday, the victims participating in this trial are today represented by Jack Proven as Junior Legal Associate, by Brescia Fossenberg as my co-counsel, and by myself, Annie Poos, as counsel.
Thank you, Victims' Counsel. Defense Counsel, you have the floor.
Thank you very much, Your Honor. The defense is represented by myself, Julius von Bonnet, Mr. Betim Shala, my co-counsel, Mr. Fatmir Pillay, investigator and interpreter, and joining us via remote is Mr. Mustafa. Thank you very much.
Thank you. And for the record, you are appearing before Trial Panel 1. Today, we continue hearing the closing statements in this case. Before we go to that, the panel will address a preliminary matter. The panel notes that yesterday at 11 minutes past 4, Victims' Counsel notified the panel and the defense that she did not file written submissions on reparations within the deadline of the 7th of September of this year, as set out in the paragraph 20 of the panel's decision 468, dated 31 August 2022. This was due to a misunderstanding of the part of the Victims' Counsel. The panel notes that it requested the Victims' Counsel to send an email. We sent her an email through CMU shortly after to file submissions by 20 yesterday evening. The panel would like to receive submissions on the submissions of the Victims' Counsel from the Defense Counsel. Defense Counsel, for the panel, we have a strong preference to receive all submissions, all relevant submissions, orally before the closing of the case. So my request to you would be, if you are in a position to reflect on those submissions when the reparations will be discussed, if you have any submissions to make on that point, of course. You have the floor.
Your Honor, we will do the entire oral arguments, including we address the issues that the Victims' Counsel has put forward in her filing. So, as far as we are concerned, we can close the entire case, as far as for the defense is concerned, today.
Thank you. Thank you for being in the position to orally present your submissions with regard to the submissions made by the Victims' Counsel. We have planned to do that tomorrow. Yes, very well. Now, then we can begin with the closing statements by the Victims' Counsel on the guilt or innocence of the accused and on sentencing, if any, for which you were allocated, the Victims' Counsel, 1 hour. You have the floor.
Thank you, Your Honours. And with that, once again, good morning, everybody. In my statement today, Your Honours, I will not seek to duplicate arguments made by the specialist prosecutor, instead highlighting some key aspects of importance to the victims participating in this case. This trial is the first war crimes case before the Kosovo Specialist Chambers. For the victims participating here, it is hugely important to finally see this trial drawing to a close and gaining more clarity. Clarity on the scope of responsibility of the accused, his guilt or innocence, and the sentence that the panel may decide on, as well as the reparations they're entitled to. What I will do today is I will firstly address the crimes and the accused's legal responsibility, or as criminal lawyers would say, the modes of liability. Secondly, we'll take some time to discuss the charge of murder in more detail to complement the presentation we heard yesterday. We'll then turn briefly to discussing the credibility and reliability of some of the evidence before the panel, and lastly, its thoughts on sentencing. The crimes for which the accused is held responsible. Victims in this case were subjected to arbitrary detention, to cruel treatment, torture, and also murder. The specialist prosecutor, yesterday morning, put victims very much at the heart of his statement and carved out in detail the experiences that they've had, and we've heard even some of the statements made in court. All this was very much appreciated. Now, one of those charges is the charge of arbitrary detention. And we've heard several first-hand accounts of victims being arbitrarily detained. Their arrests were unjust. They lacked any due process guarantees. No law justified their arrest. No warrants existed. No judge reviewed their detention. Families weren't notified, and instead, in at least one case, we heard family members were actively told lies about the whereabouts of their loved ones. An arbitrary detention is a human rights violation. To be free from such acts is one of the core rights included in the Universal Declaration of Human Rights. Article 9 explicitly states, no one shall be subjected to arbitrary arrest, detention, or exile. And why is arbitrary detention such a devious crime, as it was experienced by victims in this case? It renders victims extremely vulnerable to other human rights violations, and they are deprived of any means to defend themselves. And this is precisely what happened here. After the initial arbitrary detention, they were exposed to cruel treatment, to torture, and to murder. This is why I place this emphasis on this aspect of arbitrary detention to begin with. It was a deeply dehumanizing experience that left the victims powerless and vulnerable. It also left the family members searching, helpless, anxious, and equally vulnerable. We've heard accounts of the crime from both sides. The witnesses directly exposed to it, but also those desperately searching for a family member. Although it is difficult to untangle the impact of this crime from those that follows, it's important to emphasize that we don't underestimate what arbitrary detention alone has done to the victims. And while I will discuss the credibility of witnesses and the reliability of evidence at a later point in my statement this morning, there is no shred of a doubt that people were detained, and were detained without any justifiable reason or law supporting their detention. The accused is also responsible for cruel treatment of the victims who testified before this court, and those other victims held at the compound in Slush. The prosecution has already described in detail the conditions imposed on the victims and the harrowing abuse they endured. The cruel treatment they were exposed to was a serious attack on their human dignity, and it triggered immense suffering. And what is important to highlight from the perspective of victims is again this additional dehumanizing aspect, making them feel like or even worse than animals, wishing some of them to actually death to come to wait for their death. These conditions were combined with active acts of torture, inflicting severe physical and mental pain and suffering. The perpetrators, the accused, seemed to seek to punish those, and I cannot emphasize this enough, wrongly suspected of collaborating with the enemy or being accused as thieves, wrongly accused of this. Torturous acts, beatings that seem to seek to intimidate those with different political views. We have heard more of that from the specialist prosecutor yesterday, or targeted for other unknown reasons. Burning, beating, electrocuting, mock executions. All those acts left the victims scarred forever, physically and psychologically. The prohibition of torture is absolute, and it's one of the oldest regulations among the rules of war. And nothing ever justifies inflicting any form of torture. I have said this in my opening statement, and I will say it again here, as this is a core message that this trial needs to convey. The victims in this case all shared the feeling of how important it was to defend the people of Kosovo against Serbian persecution. But the message needs to be clear that torture is never justified. A just aim does never justify unjust means. The defense continuously asserted that what the victims had said was simply not true. This defense is not good enough. The victims not only offered their own testimony as evidence for the torture they suffered, they also offered the scars on their bodies and minds as further evidence. Independent experts, as suggested by Victims' Counsel and ordered by Your Honours, the trial panel, examined some of the direct victims. And these experts confirmed in their reports that the victims' bodies show multiple scars and very significant and distinct impairments that are fully consistent with the torture, with the torture described. It is very powerful evidence. It also documents the psychological impact the crimes have had on victims. They continue to suffer from post-traumatic stress and relive that horrific time in nightmares and flashbacks. The experts who delivered these reports are working to internationally recognized standards and scientifically agreed approaches. They have adhered to the Istanbul Protocol, an internationally agreed manual on the effective investigation and documentation of torture and other cruel, inhuman, and degrading treatment when they were conducting their examinations and issuing their reports in this case. It is striking, to say the least, that the defense did not raise any objections to the choice of experts, their methods, nor the viability of their reports. It did not oppose the admission of these reports into evidence. These reports, in our view, leave no doubt that the experiences of cruel treatment and torture described by the direct victims were not made up, but concern very real and very traumatizing events. And the accused is one of those responsible for these crimes, as I will now discuss. With that, let me turn to the modes of liability. We've heard evidence from different witnesses that pin the accused, Commander Salih, the man with the red hat, directly to the crimes, to situations of arbitrary arrest, and directly to torture. This evidence clearly indicates the direct involvement of the accused in the crimes and allows prosecution as a direct perpetrator. The prosecution has discussed this amply and provided evidence on this. He was the one starting the mistreatment of one of the witnesses, said, "Finish him off," to his fellow fighters under his command. He conducted a mock execution. He was present at the scene. And when he was moving around the region, he was able to communicate with his unit. He had access to satellite phones and to a vehicle. We agree with the prosecution that the accused and other members of BIA can be regarded as a joint criminal enterprise in its basic form, commonly referred to as GCE1. The common plan included the crimes of arbitrary detention, cruel treatment, and torture. They acted together, and the accused participated in this enterprise. Indeed, he even led it. Even if the main purpose of BIA may have been to free Kosovo from Serbian persecution and fight for its independence, BIA's actions, sadly, make clear that as a small part of that bigger plan, they detained those they identified as unwanted, as spies, as thieves, or simply as having an opinion they didn't like. And this form of criminal enterprise, joint criminal enterprise, is undoubtedly part of customary law. While the debate rages if another form of joint criminal enterprise, GCE3, would also be part of customary law, this, in our view, is not of relevance at this point of the case against the accused. We also heard ample testimony that the detention, the cruel treatment, and the torture was done by members of Skifterat. Skifterat, as the defense case actually itself demonstrated, was another name for BIA, a special guerrilla unit. And the accused was the commander. Not a single defense witness left any doubt on this. The accused was a respected commander with authority. There's nothing that would suggest that the BIA unit was not under his control or doing things he didn't want them to do. On the contrary, the defense case was a demonstration of the esprit de corps that existed in the unit. This is why the accused, Commander Salih, is also responsible under command responsibility, reflected in Article 16, paragraph 1c of the law, which is a distinct mode of liability. And while the SBO has discussed this, I would like to offer two complementary legal observations here. One is that command responsibility was clearly part of customary law at this time in question in 1999. The Rome Statute of the International Criminal Court from 1998 reflects this, as does the European Court of Human Rights recent judgment in Milanovic versus Croatia from January of this year. And, this is my second point, this mode of liability applies, in our view, cumulatively to liability under joint criminal enterprise. In Article 16 of the law, there's nothing in the wording that would suggest that the modes of liability mentioned therein are mutually exclusive. We then also look at other instruments such as the Rome Statute of the International Criminal Court. Article 28 of the Rome Statute begins with a preface, in addition to other grounds of criminal responsibility. But beyond the wording, what is important here is that the purpose for command responsibility is to highlight the special role a commander has in enforcing the rules of war and to ensure that any armed conflict is conducted as humanely as war can ever possibly be. It is a duty to prevent any breaches of international humanitarian law, and where a unit gets out of control, it is the commander's duty to punish those responsible to ensure compliance. And this purpose is very different to that of other modes of liability. Salih Mustafa, he was the commander of the BIA unit. The trial leaves no doubt on that whatsoever. And when he wasn't personally involved in the crimes in question, his subordinates were. He knew, and he had reason to know what was going on in Slush. He was present, and he was, as I said before, directly involved. He took no measures to stop them. His failure to do the right thing as a commander, to prevent and punish acts of torture and other crimes, contrasts with his direct involvement and therefore is cumulative. As a commander, Mr. Mustafa, you had the duty to protect victims. Instead, you and your men conducted arbitrary detentions and committed the crimes you are charged for. Under your watch, at least one was murdered. Although the defense has gone to some lengths to set out how you moved around and were not always present in Slush, this does not relieve you of your responsibility. And I'm saying this here so directly because victims haven't had the chance to encounter the accused who wasn't present in the courtroom. With that, let me turn to the charge of murder and focus for some time on this specific charge. It deserves some special attention because the surviving direct victims in this case were all clearly shaken by the fate of their fellow prisoner who was murdered. It has left many people traumatized, vulnerable, and continues to impact their lives to this day. We have heard in detail, and it has been described yesterday as well, how one victim was singled out amongst those arbitrarily detained and tortured. Indeed, the surviving victims who testified described how the murdered victim had been repeatedly tortured more than anybody else. He wasn't able to walk or stand any longer. He had, as one victim had said, and we heard yesterday, been massacred. He was more dead than alive. He was later found buried in a shallow grave in close proximity to the detention compound. And the body had been decomposing, indicating that the death must have occurred sometime before he was found. Let us confront the fact, as the prosecution has done yesterday to some extent, that we weren't able to fully establish the exact moments of the victim's death. It will continue to leave open questions for those who want to fully understand what happened. But I agree with the prosecution that this lack of knowledge about those final moments does not mean that we cannot hold the accused responsible for murder. Based on the evidence we've heard throughout this trial, only 3 explanations for the victim's death are remotely possible, and the most plausible scenario has extensively been discussed by the prosecution. I will therefore reduce my presentation with regard to this most plausible scenario to only sketch this before confronting the legal consequences of other scenarios. This most plausible scenario is that BIA members committed murder by actively taking the victim's life before leaving the compound in sludge. While we can only speculate as to why the BIA members would have done this, it is possible that they feared identification or that the victim would have been an unwanted burden in the ongoing evacuation. After all, he was incapable of walking due to the torture he had suffered, and the evidence suggests that his legs had possibly been broken. Whatever their reasoning, the scenario in which the victim was actively killed by BIA seems most plausible, considering the photographs seemingly displaying a gunshot wound to the torso. Or this would, at least, trigger the accused's responsibility as a commander. But let me focus on these other 2 scenarios. The second one. It is, in theory, possible that when BIA vacated the slush compound, the victim was left behind in the face of the advancing enemy forces and then died as a result of wounds inflicted by BIA previously. Although I agree that this scenario is far less plausible, it would still render the accused responsible for the victim's death. And I want to take a moment to spell out why. As a reminder, the elements of the crime of murder as a war crime have been established in the jurisprudence. The ICTY appeals chamber, for example, in the Georgievich appeals judgment from 27th of January 2014 at paragraph 548 spelled out that the following elements are required. The death of a victim taking no active part in hostilities, the case here, clearly. Also, it requires that the death was the result of an act or omission on the part of the perpetrator or one or more persons for whom the accused is criminally responsible. These acts here being the numerous acts of severe torture that left the victim more dead than alive. As we have heard, it was a massacre. And, lastly, that the perpetrator intended to kill the victim, willfully harm or inflict serious injury with reasonable knowledge that the attack was likely to result in death. This mens rea element is fulfilled here as well. Torture of this severity that this trial has shown with respect to the murdered victim is most likely to result in death. In many ways, it is the even more cruel scenario to leave someone so gravely injured to die a painful and possibly even a slow and long death. And the last, although in my view least plausible scenario, would be that the victim was left behind in his gravely injured state that rendered him unable to walk or run, to seek shelter, and that in theory he could have been hit by enemy fire. And I emphasize again, in theory. This as the last straw that finally killed him. And even then, this would not relieve the accused of liability. Because the victim was a detainee of the accused unit, they had a duty of care towards him. Leaving this person defenseless against an enemy known to persecute Kosovo Albanians also equates to murder. In this case, it would have only utilized the Serbian fire to finish the job. Although, and I repeat it again, this last scenario appears least likely and barely possible in the face of the evidence we have heard, it is important to consider it, as the defense seemingly suggested that this could have been the cause of death. Nevertheless, even in this constellation, the legal elements for murder are still fulfilled, specifically the intent to kill, and I focus on this here. And allow me to draw again on ICTY jurisprudence here, which is informative in this regard. For example, the ICTY trial chamber in Orange, 30th of June 2006, in paragraph 348, held with regard to the war crime of murder that the intent to kill, of course, is required to fulfill the mens rea, and this includes proof of a mental state wherein the perpetrator foresees as more likely than not that the death of the victim could occur as a consequence of his act or omission, and he nevertheless accepts that risk. In Martic, similarly, 2007, 12th of June, the ICTY stated at paragraph 60, the mens rea of murder is the intent to kill, including indirect intent, the knowledge that the death of the victim was a probable consequence of the act or omission. And again, leaving a gravely tortured and half-dead man without shelter in the path of hostile forces, hostile advancing enemy forces, clearly contained the probable consequence of the victim dying. It was more likely than not that this would occur. We heard, not least from defense witnesses, that the accused was actively involved in the evacuation of the wounded from Slush. If the accused gave active orders on what should happen with the victim, he is directly responsible, and we know that. If he did not engage further with what would happen with this gravely injured prisoner and left this to his men, this doesn't relieve or lift his responsibility. The accused at least had reason to know that the crime of murder would be committed. The had reason to know element that an accused, or requires that an accused must have been in possession of some general information which would put him on notice with regard to command responsibility of possible unlawful acts. And again, allow me to draw on the ICTY appeals chamber here in the Celibici judgment, for example, in 2001, in paragraphs 237 and following. An interpretation that has been followed by the ICTR, for example, in the Nahimana appeals judgment. And there it was clarified that this information does not need to provide specific details of the criminal act itself. The liability of the accused for the murder therefore rests on his possession of general information, which would give him reason to know, at the minimum, of the likelihood of the crime. This means that the accused would still be liable, even he did not have specific details of the murder itself. He knew of and he was involved in the illegal detention and torture. He was leading the efforts of getting the wounded out of Slush. Defense witness Hadri, already we heard her cited yesterday, felt compelled to state during the trial when describing the evacuation from Slush, and I quote here, "I publicly thanked Salih and the other soldiers that because of them I am alive today. I thank them for the organization they provided to save our lives as medical staff, of civilians, of the injured." End of the quote. The deceased was not so lucky. the victim, beaten so severely that he could not walk or stand up any longer, wasn't saved. Either actively killed or left behind. The accused had all the information necessary to know that this would be happening. And this is why the accused is responsible for murder, as well as arbitrary detention, cruel treatment, and torture, and has to be punished accordingly. Let me now turn to discussing very briefly the credibility and reliability of some of the witnesses and the evidence before the panel, because I can echo there much of what the prosecution has already presented, and to avoid any duplication, I will keep this as brief as I can. Some additional observations are critical when we want to evaluate the credibility of witnesses here and the reliability of their statements. The panel will need to take extra care in considering the effects that the long-lasting trauma induced through the crimes in this case have had on witnesses. It will also need to pay specific attention to, for example, the effects of power dynamics that continue to subtly, or sometimes not so subtly, influence witness behavior, and also lastly, communication and cultural barriers. We've seen that different witnesses presented themselves very differently throughout this trial. We saw very, very distant behavior. We saw those efforts to stay in control. We also observed moments of anger, of avoidance, of distress. In short, we had a whole range of different behaviors that were displayed by those who reported of the crimes they had suffered. And this range of behaviors is to be expected in survivors of traumatizing events. A survey of recent research in the field has shown that a strong body of evidence indicates that survivors who experience symptoms of post-traumatic stress disorder may, for example, suppress emotion to avoid becoming overwhelmed or induce a state of disassociation. And this is particularly prevalent when, as is of course required in testimony giving, a traumatic event or traumatic memory is reactivated. The effect of trauma on memory, on the way in which the brain encodes information, can actually differ hugely between different victims who have experienced similar things. For some, this can make it very difficult to recall or recount details in a linear or in a very sort of complete way, telling one coherent narrative in one go, whereas others may achieve a very detailed account, one which is nearly surprisingly detailed. And in short, these specificities of effects of trauma on memory will have to be taken into account by the panel when assessing the testimony of the witnesses before it. With that, I will now discuss some elements of the testimonies provided by the individual witnesses, and will do so to the biggest part in open session, and therefore keep it short and at times do not go into as much detail as I would otherwise, but I think for the benefit of the public, this is nevertheless useful and will not take away from the argument. There will only be a very brief session which we will have to conduct in private. Having said this, let me turn to the testimony of witness 01679, who delivered an important and a very detailed account of his ordeal in Slush. Although struggling with post-traumatic stress, It was impressive to see his efforts to stay calm and to stay in control. He clearly tried not to be overwhelmed by emotion. And in my view, there can be no doubt whatsoever that this witness is credible. He was able to provide a testimony of substance with many details that were subsequently independently corroborated, as the SPO has already demonstrated. A poignant fact was that the witness was able to identify one of his torturers with the nickname Beamy before it was mentioned in court. Witness 01679 also delivered a very detailed and consistent account. He provided clear explanations as to why his SPO's witness statements were not as consistent with previous statements in the UNMIC proceedings. And let's face it, those proceedings were riddled with flaws. As a mission, UNMIC at that time didn't have the professional capacities to ensure adequate witness support, to ensure trained and professional interpreters, all those ingredients necessary to ensure the integrity of proceedings and to ensure conditions that allow for an authentic account of events to be taken. The witness's account of torture he suffered is also corroborated, and I've mentioned the report before, by the medical and psychiatric examination, in which two experts jointly concluded that his scars, his injuries, and his mental state are strongly consistent with his account. Adhering, as I've mentioned before, to the standards of the Istanbul Protocol on the investigation of torture, this result is as strong as it can get. We can never fully determine, or with full certainty determine, the cause of an injury after many, many years. But a strongly consistent picture was seen by the experts, which is a result that is important to consider, and it's important to emphasize that the witness didn't have to undergo this, for him, very stressful examination. We didn't have to suggest this form of evidence, yet his wish to contribute, and it evidences how strongly he feels about bringing truth to light. It bolsters his credibility and the reliability of his account. Witness 04669 was another direct victim who testified before this court, and equally credible and reliable in his account of events leading up to and during his illegal detention in Slush. He testified in a very calm and in a very collected manner, supported, although restrained by body language, making great efforts to keep negative emotions at bay that could have been triggered through the recollection of events. He also underwent examination by the experts, voluntarily exposing him equally to a stressful and to an invasive experience. And this examination also confirmed that the witness's body featured scars consistent with his account of the beatings he received. His testimony also contained details that were later corroborated by other witnesses. Didn't just confirm the description that the previous witness, witness 1679, had given of the training and the school in Slush. Nearly ironically, defense witnesses were among those who provided corroborating details. For example, the KL8 trainer who was a black belt in karate, Musli Halimi, who confirmed this. Or the incident with the Serbian helicopter falsely using humanitarian insignia, the Red Cross, to guise an attack, an incident later confirmed by Sedi Veseli. This context, of course, is important also as it was a motivation for the witness and many, many other people in Kosovo to fight with the KLA, to participate in the armed conflict that was ongoing at the time. This was actually one of the devious sides of the crimes committed against the victim. He believed himself to be among fellow Kosovars who fought for the same cause. We now turn to discussing the testimony of witness 03593. Again, I have no doubt that he was arbitrarily detained, that he suffered torture and cruel treatment. The core description of his ordeal was coherent and consistent across his different statements. He even attempted to show scars that were physically visible. He reported many of the indicators of trauma: nightmares, sleep disturbances. And yes, as we've heard yesterday as well, and the panel will remember this, the witness avoided saying the name of the accused when he was providing testimony here in court. His refusal, albeit seemingly irrational, considering previous statements and his testimony overall, can be explained based on actually two considerations. The one is one that SPO has discussed yesterday, which was the immense pressure the witness was under. The other one I would like to highlight is that we may also have observed here that a traumatized witness employed actually an avoidance strategy to dissociate from the person he identified as the key tormentor. Doesn't seem to make much sense to us, but within the emotional mindset such a victim is in, this is one other explanation to consider. The witness had been subjected to very long and thorough cross-examination to the extent that he nearly felt mistreated and violated, having to relive his experiences and confront trauma for various consecutive days. Although the defense has taken the mantra-like position that all of these witnesses are simply not telling the truth, there is nothing that would explain why they should lie and put their life at risk. All those direct victims have been able to provide insights into their experiences in Slush. It leaves no doubt that torture happened and that it was the BA unit under the command of the accused, under the command of Commander Salih, responsible for the crimes committed. All three men are unconnected to one another, and we've heard this yesterday. The only common element is their experience in Slush. All of them had a lot to lose by testifying in this case. Now let me turn to witness 03594. His testimony in court seemed less credible than that of the other three victims detained in Slush and provides only limited probative value. It was in parts significantly inconsistent to a previous statement, even more so. He presented details in court which would have been significant from his point of view as a position as a witness, yet he only came up with them when we were hearing him here. The defense repeatedly referred to the 100 Deutschmark moment. And I would think that all of us still vividly remember this. Or let me recall how the witness described that on the march from Slush after his release, he had stopped to shave. Rather striking, given that they were fleeing from advancing enemy forces. It was peculiar when he described, in a rather unsolicited manner, that other victims didn't have any broken arms, broken limbs, or broken teeth. This witness, in our view, clearly was on a mission to mitigate any acts that could be linked to the KLA or to the accused. His motivation may rest in personal motives expressed during his testimony. That may be enough pressure to try and limit any damage done by him, damage in inverted commas, in previously testifying to the SPO. And despite these efforts of minimizing any wrongdoing by the accused or any of the unit, the witness did corroborate some elements of other victims' accounts. His illegal detention, as well as that of others, the description of the location and compound in Slush, which overlaps significantly with that of others, the wooden beams on the ceiling, the elevation of the area, the room above the stable, old wooden planks. He confirmed the presence of certain witnesses in Slush, confirmed that he did see some marks on their body, confirmed the release on the 18th or 19th of April, 1999, in the context of the beginning Serbian offensive, as well as the walk from Slush to Pristina. And he confirmed that the conditions in Slush were inhuman and, in his words, worse than the treatment of animals. In their no case to answer motion, the defense seemingly attached a lot of weight to the testimony of this witness, yet it has failed to engage with the fact that even this witness confirmed the charges of arbitrary detention and of cruel treatment. Could I now please ask the panel to move into private session so that I can discuss some details which may be identifying in order to ensure continued protection of the witnesses in this case, please.
Thank you. Madam Court Officer, could you bring us into private session, please?
Your Honours, we're back in public session.
Thank you. Victims' Counsel, you may proceed.
Thank you, Your Honours. So all these latterly discussed witnesses didn't try to pin any responsibility on the accused where they were lacking such knowledge. They did not try to exculpate the accused either. Instead, their testimonies were characterized by the great pain they are under. Some were visibly under incredible stress, in parts shaking, getting very emotional, yet making all efforts to keep focusing on their testimony and deliver it to the best of their abilities. With that, Your Honours, let me now briefly add some observations on actually how the defense case has confirmed and corroborated some of the victims' testimony. They confirm details that the victims could really only have known if they had indeed trained with the KLA and been in the slush compound. Already named a couple of incidents, such as the black belt in karate. In fact, these defense witnesses in some way support the experiences of victims and help to confirm credibility and the value for establishing and the value of their testimony for establishing the truth. Musli Halimi, already mentioned as the witness who confirmed that he was a trainer with a black belt in karate, also confirmed the account of witness 04669, that the recruits didn't practice shooting with live weapons but with air guns. Halimi had explained the rationale for this, that this was done in order to preserve ammunition. Again, it's one of these small details that seems nearly irrelevant for the charges as such, but important to show that it's an authentic experience he has recounted. Witness 01679 described the room he had been taken to upon arrival in Slush. Entering a building, he said, there was a corridor with a room to the left and a door to the right. He was taken to the room on the left, which contained chairs, a desk, a wardrobe, boxes with things, and had wooden planks. Witness 03593 had also remembered the wood and all the different sorts of stuff in this room. And these details now are corroborated, for example, by witness Hadri, who refers to this building as the headquarters. She described a corridor with a room on both sides. In the room to the left, there was a desk and a man sitting behind it with a portable computer and a satellite phone. We note that several defense witnesses actually confirmed that the KLA had satellite phones and that, in fact, the accused had access to one. But in any case, the key point here is the office-like setup of this room described by Hadri that corresponds with the testimony of direct witnesses. Victims also described how they had been brought upstairs and downstairs for the interrogation and torture, and amongst other methods, by electrocution using a box that would be wired to the legs. Though the defense has attempted to show that there was no electricity at the compound, and the prosecution also alluded to it, so I will keep it brief, two defense witnesses confirmed explicitly that electricity was available. Hadri not only confirms this, but remembers watching television while on the Slush compound. Witness Kanoli Kachiu in turn testified that batteries were used at the compound to provide energy and light, a small detail which also corroborates the testimony of witness 03593, who recalled that battery-operated torchlights were used at the detention locations. These brief examples suffice to show that the corroborative effect that the defense case has had on the testimony for the testimony of the witnesses. The defense witnesses were nearly all turned out to be members of the BIA guerrilla unit themselves, strengthened what victims said rather than undermine their testimony. And in our view, the defense case is not persuasive. Victims hope that the prosecution of the accused will not be the only one holding those to account who contributed to their suffering. With that, let me offer in closing very brief remarks on sentencing. Murder and torture are among the most serious crimes. What victims want to see is that the accused receives a just sentence that reflects the extent of his responsibility, can only echo the very detailed observations that have been made by the specialist prosecutor. One thing for us stands out, and that is that the accused had a specific responsibility as a commander to ensure compliance with the rules of war. Instead, he was an active part of the commission of war crimes for which he is on trial here, and this needs to be reflected in the sentencing. And the crimes destroyed not just the life of the murdered victim. They have a continuous impact on the surviving victims. The crimes destroyed private lives, and it impacted and continues to impact victims' health. The extent of the damage done is huge. It's been set out in detail in this case, and we have heard about the brutality and the extent of suffering. It goes without saying that all these are aggravating factors that the trial panel should take into account in its sentencing. However, victims will not request a specific length of sentence for the accused. What they want to see is their suffering acknowledged and the accused punished justly. With that, let me draw to a close, and I thank you all for your attention.
Thank you, Victims' Counsel. It's now 25 minutes to 11. Defense Counsel, I propose that we adjourn the hearing now, and then you will have more time for taking into account, if need be, the submissions made by Victims' Counsel. And my proposal would be to start, as usual, with the next session at 11:30. Is that agreeable for you?
You sure, Your Honor? It's okay. We're ready, but it's okay.
Okay, very well. Good. We will continue at 11:30. The hearing is adjourned.
Rise. All rise.
Please be seated. Welcome. We will now proceed with the closing statement by the Defense Counsel. And before I give you the floor, Defense Counsel, I want to remind you that whatever you will display in the courtroom for the public can only be used by the panel if it has been properly presented before the deadline for the closing of the evidentiary proceedings in accordance with Rule 134 of the Rules of Procedure and Evidence. And after having said that, you have the floor.
Thank you very much, Your Honor. In the indictment of Salih Mustafa, the SBO treated the so-called contextual elements of the allegations against Mr. Mustafa. It alleges in paragraph 5 that the BIA consisted of approximately 500 to 600 soldiers, which operated predominantly in the urban areas. It claims that the BIA unit operated from a compound in Salih, and it claims that the BIA used the compound as a safe house, as well as a detention and interrogation site. The defense first would like to take a look at the terminology used in this part of the indictment. The approximately 500 or 600 soldiers, what is it actually? People who worked with the KLA might think they are soldiers, but in case of BIA, it's nothing further from the truth. There is no documentation regarding any of the people who actually belonged to the BIA. There was no enrollment, and neither was there any kind of training. There were no ranks, no uniforms, no command structure. People were committed to liberate their country from one of the most oppressive regimes in recent history. The Serbian domination of the people of Kosovo initiated that many people were supporting in one way or another way the fight for liberation and self-determination. We have heard in court many people who say they belong to the KLA, sometimes to the BIA. None of these people that stated that they would belong to BIA had received any form of training, did not have any rank, did not have any special insignia, or were enlisted as a BIA member. In the case that we heard people from Barileva or elsewhere, these were people that were committed to the liberation of Kosovo, and they voluntarily worked for whatever work they could do in order that Kosovo would eventually succeed to liberate itself. Therefore, the terminology soldier for the people who were thought themselves as part of BIA is not correct. They were citizens who helped the war effort as such, but had no military role whatsoever. As for the KLA, we can indeed say that even as the men were a volunteer, this looked much more like a military organization. Brigades were set up, and the areas of operations were determined in which these brigades operated. The brigades operated in several areas, and among those areas was the Golak area, and indeed was also the Slash area. The BIA operated only in urban areas. Citizens would use their house or let their houses be used by people in order to see movement of troops, cars, military vehicles from the Serbian armed forces. They would pass on the information, and that would be useful for what was going on in a particular area. It is this kind of gathering of information in order to know what enemy forces were doing or if they would have any operations going on. People of BIA were not disciplined. They did not have any actions regarding the Serbian forces. They had no relation to brigades whatsoever. The brigade had no control over people of the BIA, and BIA had no control over people from a brigade. It is as simple as that. It is a total misconception that the BIA operated in Slash. They did not. Maybe people from BIA might have been present there, but they did not have in any manner control over anything in Slash. The BIA did not operate in any particular area in Slash. They had nothing to do there. There was nothing that was of any particular need to have their presence. In short, the BIA had no operations whatsoever in Slash. The specific area that has been described in the entire case is the compound, which means a small group of structures. These structures were located on a hilltop and has been discussed with many of the witnesses that have come to testify here in The Hague. That location was a location owned by the family Krasniqi. That family gave the KLA the opportunity to use it. Indeed, people from BIA would use this location. The use was to take a rest after their activities in Pristina. They had no specific activities in Slash or in the Golak area. Mr. Mustafa called this location a safe house, a place where people could stay for a while and move on to any other activity that might be necessary. The entire notion of this compound being used as a base for BIA is just completely wrong. BIA people had no authority there. The entire compound was used as a safe location for refugees, that is, internal displaced people from other areas, who could stay there safely. Many witnesses have spoken about this, and we have mentioned those in our final trial brief. None of the people who were staying in Slash said that it was the BIA who operated this compound, or would have said that it was only BIA who would have the monopoly over this set of structures. We will get to it at a later stage. But the allegations that the BIA would use a certain building for the purposes of interrogating and the detention site is simply false. I return to the allegations that are in the indictment. People of the BIA were not in any manner soldiers. They had no combat or even non-combat training as soldiers. Non-combat in the sense of tactical or logistics. And they did not have any missions related to combat. People from the brigade would have such function. And there was a clear command structure. People from BIA would not fall under the command of any brigade. It is an entirely separate unit, and they certainly help the war effort as a whole. One wonders why, in fact, people from BIA would detain people, or why would they even interrogate people? Why would they collect any information from simple citizens at all? It's an important question to answer, and there must be some purpose to do such things to people. What possible information could the people who say that they have been detained provide to the BIA. There have been no instances recorded where the units of the KLA brigade operated in concert with each other to achieve some kind of specific goal. So to simply allege that the BIA people would take such action is really very far-fetched. The BIA had no joint operations or activities with the police or guards of any kind. So why on earth would BIA members, KLA soldiers or police or military police work together in a joint manner with a common purpose to interrogate and mistreat people? And why would they do that suddenly in the period of the indictment from the 1st until the 19th of April 1999? The defense wants to make it very simply clear. Salih Mustafa nor any other BIA people had neither alone or in a joint manner with other KLA soldiers, police, military police, or any common purpose to arbitrarily detain, mistreat, or treat cruelly, torture, or murder anybody at all. Salih Mustafa had no intent for the commission of these alleged crimes, and neither did anybody else have such intent. In fact, they simply never committed any of these alleged crimes. There was no such thing as a joint criminal enterprise in which Salih Mustafa or members of the BIA played any role in the commission of the alleged crimes as stated in the indictment. Mr. Mustafa did not participate in any joint criminal enterprise, whatever the composition of such enterprise might have looked like or might have existed. Mr. Mustafa vehemently denies all the charges. Mr. Mustafa had no knowledge whatsoever of the crimes alleged in the indictment. In the period of the 1st until the 19th of April, Mr. Mustafa has been maybe a couple of times in Salih at the compound. He never detained, interrogated, mistreated or tortured anybody there on that place. He also did not order anybody to do so. He also did not oversee any of these alleged actions, what would have been taken by others. There is no evidence that he even knew that such things happened, and he never witnessed any such things. Mr. Mustafa never killed anybody and never ordered anybody to be killed, nor did he subject anybody to torture or ordered that to be done. Mr. Mustafa has never been aware of such things. There is no evidence that there is any relation or connection between Mr. Mustafa and KLA soldiers with nicknames such as Tabuti, Ilmi Vela, Bimi, Dardan, or Afrim in committing these crimes, if these crimes were at all committed by any of these individuals. Bimi denied it himself. Others were never found or interviewed, and there is no evidence that these people were at the time of the indictment in the compound. They have never been even identified. Neither Mr. Mustafa nor people from the BIA had any authority over the compound, the structures, the people that were present there, or things that took place there. There is no evidence whatsoever that Mr. Mustafa had any means available to him that he would use to order people to undertake the alleged crimes in his absence. The word BIA came in this context many times back in the indictment, the confirmed indictment. If we take a look at the witness 1679, what did he say about Bia? A question was asked on him. At an unknown place for him, 7 or 8 kilometers away from where he was taken. Up to that moment that he was brought to the first barn, he had a bag over his head. At the time he had a bag over his head until where he got into the first barn where he was placed, and that place was not more than 5 meters in size. He spent there about 1 hour, and then he was placed into a second barn. That second barn was covered with something. When he was transferred to the second barn, once again, a bag was put over his head. The second barn was 5 or 6 meters away from the first barn. The next day, he was taken to another barn, together with the alleged victims of the murder in this case. And this one was 15 to 20 meters away. Once again, a bag was put over his head. It's written in the transcript, 20 September, page 402, 403, 406, 7, and 416. Upon his release, he stated that there were a lot of people in the yard in civilian clothes and uniform. I quote, "I do not know whether there were 1, 2, or 3 buildings. They were not far away from where I was. So they were about, 50, 60 meters away. Starting from the building where I was kept, it was a path. It was not a good path. It was mainly meadow. We couldn't sleep at all because the upper part was just with wood, covered with wood. And while the people were being beaten upstairs, we just couldn't sleep because we were scared." 20th September transcript, page 476. The conclusion, Your Honor, on the identification of the general location where witness 03593 was kept is the following. Indications that he had a bag over his head. So under those circumstances, the witness cannot identify the general location where he was kept. Second, the distances that he indicates cannot objectively relate to any other of the structures at the Slash compound. The entire compound is less than a quarter of a football field. compound is maximum 41 meters in size. And the fourth point, he indicates that he does not know whether there were 1, 2, or 3 buildings. From the aerial pictures, it is clear that there were at least 9 structures in and around the compound. The yard from one side to the opposite side would not measure more than 35 meters. The witness is not sure whether he was there before, so he's not in a place to recognize from earlier times. Therefore, objectively, his identification of the general location of Slash or the Slash detention compound cannot be accurate. The defense is of the opinion that the witness is not reliable to this aspect. W1679. The witness said, "We continued the road and walked all the way. We arrived at a place that I do not know to describe it to you. It was the first time that I was seeing that place. We arrived at that place. They told me to lower your head. I did not know what was happening. When we got closer to some buildings, there was a sack, a black sack, if I'm not mistaken. They put it on my head, and they took me into one of the buildings." The witness stated this on the 4th of October, page 867 of the transcript. I continue. "They took me to the same building, but downstairs. There was a barn there," page 882 of the same transcript. "From what I remember," same page, "from what I remember, it was a building made of stone. There was a wooden door. There was some hay, dampness." Upon his release from the place of detention, the witness did not state anything as to the general location where he had been kept. The transcript spoke about his release. The witness spoke about his release on the 5th of October on page 867 of the transcript. 5th of October 2021, that is. The conclusion regarding the identification of the general location where 1679 was kept is the following. 1. The witness, by his own account, does not know how to describe the general location of the place where he was kept. 2. The witness stated that he had a bag over his head. Under those circumstances, he cannot identify the general location. 3. The indications that the building was made of stone with a wooden door are not specific or particular for any house in the area of Golok. And 4. Even upon his release, when he had no sack over his head, the witness did not state anything about the general location where he had been kept. And I add to this that the witness drew a sketch himself. It's ERN 060694. That sketch indicates only 3 buildings, and none of them are connected to each other. General conclusion is that in the opinion of the defense, the witness is not reliable on this aspect. Then witness 3594. The witness is a witness that was able to give a general description of the location where he was kept. He described it upon a question of the defense. The question was, in addition to this old house that you are speaking about, have you noticed any other buildings? The witness answered, no. And he continued, when I got there, I did not see anything else, because I went straight. I did not look on my left, but I only looked on my right. And there I distinguished that old house when I entered. It was in the statement 13 October 2021, page 1174 and 1175 of the transcript. And he continued to describe what he saw. When I went out, I saw that there was a large yard and that there was another building that was kind of attached to the yard. I saw this space and I saw that there were 2 houses within the compound. I do not know who the owner was of that house, but there were 2 houses opposite to each other. I saw 2 houses. In particular, the witness stated, if when one went out of the barn, you could see nothing because there was this haystack opposite the barn. But you could see, but if you go a bit further up, it was an elevated area, there where I was taken to have a conversation. When I went to that elevated area, I saw it was a flat area, and that it is when I saw that there was another house. And upon a question of the presiding judge in that moment, the 13th of October 2021, was it 1 or 2 houses? And the witness responded, with the house where we were, there were in total 2 houses. The witness stated this on 13th of October, page 1176 of the transcript, 1176 and 1177. And lastly,
Defense counsel, sorry to interrupt you, but I would like to go just for a moment into private session.
Sure.
For a specific issue I want to touch upon. Madam Court Officer, can we go into private, please?
Your Honors, we're back in public session.
Thank you very much. Defense counsel, you have the floor again.
thank you very much, Your Honor. I pick it up with witness 03594, where upon a question of the defense he was asked, was there any house or structure attached or nearly attached to the barn or to the house in which the barn was located? And the witness stressed, I did not see any. I don't know. 13 October 2021, page 1178 of the transcript. I'll say 1178 of the transcript. The conclusion, Your Honor, regarding the identification of the general location where 3594 was kept is the following. The witness said that there were in total 2 houses. 2. He said that there was a haystack opposite the barn. 3. He said that he did not see any house or structure attached or nearly attached to the barn. 4. The witness could normally see this as he had no sack over his head and he was able to observe. And lastly, his observation made it clear that the place where he was cannot be the Salih compound. The Salih compound at the time consisted of at least 9 structures on a rather short distance from each other. Our general conclusion is that this witness was able to make observations, but his observations make it clear that he apparently speaks about a different location than the Salih compound. The defense is of the opinion that the witness is reliable in this respect. Witness 4669, Your Honor. W4669 spoke about the general location of the place where he was kept. Upon a question of the presiding judge regarding what the witness saw around once he went outside the barn where he was kept, the witness responded, "Nothing, just a field, a green field and a toilet." This is how the witness said he remembered it. And upon a question of the presiding judge, "Did you see any buildings?" the witness replied, "No, only the one that I exited to go to the toilet, and there were buildings near that one, around it, and we were not allowed to look on our right or on our left, just had to go straight and then back." And the judge continued, "And the buildings near the one you were exiting, how many buildings were that?" About 2 or 3, very close to each other, almost attached to each other. And there were others a bit further according to the configuration of the terrain. And again, the presiding judge asked once again about the location upon his release. And in this case, the distance between the school and the place where the witness was detained. And I quote, "What I understood, that you said there that between the place you were held, the barn, and the place that you had training, and from my understanding that was the school, you said it was no further than 200 meters. He answered, "Approximately that was the distance. I can't tell you exactly, but it was that, the distance. Because about the training and the exercises, we hold those trainings outside in the mountains. I don't know whether you're talking about the training inside or indoors or outside. Because, like I said, we had theoretical parts at the school, whereas outside, outdoors, we had physical training. However, in general, the building is in that distance, because I can't really exactly tell you what the perimeter of the place was, but approximately that is correct." And he stated that on 11 November 2021, page 1575 and 1576 of the transcript. Our conclusion, Your Honor, about this witness is the following. The witness did not identify any buildings. He did not even identify the building in which he was kept himself. He was brought there by witness 4600, who also brought the alleged victim of the murder of this case. He does not give a description about other structures that he saw and that were attached or nearly attached to the one he was kept in. But he only spoke about maximum 3 buildings close to each other. Last point on this, the building where he was kept was not further than 200 meters from the school where he was trained. So our general conclusion, Your Honor, this witness, had no sack over his head or was not impaired in his vision. The fact that he indicates that the building was only 200 meters away from the school amounts to the conclusion that this was not the Salih compound. The Salih compound is at least a 20-minute or more walk from the school. The witness speaks about a different location than the Slash compound. The Slash compound has 9 other structures, so the witness is speaking about a different location. Defense witnesses, at least 5, Hadri, Kanoli, Krasniqi, Ayeti, and Humoli, were all able to describe the general location of the Slash compound, which consistently corresponds with the aerial photos in the case file. Another topic is the fence. Witness 3593 said nothing about the location in general, so he did not say anything about a fence that would have been around the compound. 1679 said nothing on the topic. 3594 then. He said he did not remember. He said he did not think so. He did not look. I quote him, "If there was one, then maybe behind the houses in the opposite side of the house. That is behind the house. In front of it, I did not notice any." 13 October 2021, page 1181 of the transcript. Lastly, Your Honor, 4669, on the question of the presiding judge, was there in that place where you were detained, was there a fence around that place? The witness replied, "A fence?" with a quotation, with a question mark. Maybe there was, a bit further, but not close to where we were. There was a small part of a fence. A fence is usually made of sticks, of wooden sticks, to my understanding. But was there a fence or not? Not the one that you think, the witness replied. There was just one small part, but very far from where I was, about 30, 40 meters further away. This is how I remember it. 11 November statement, page 1546 of the transcript. Our general conclusion about this witness. None of the witnesses said that there was a fence around the Slash compound. Only one witness gives an indication about the fence, but says, not the one that you think. From the testimonies of the SBO witnesses, no conclusion regarding a fence around the Slash compound can be drawn. On the other hand, the defense witnesses consistently stated it was an open area without a fence. Witness 4600 then. Witness 4600, who allegedly delivered the alleged victim of the murder in this case at the compound, stated that he did not recall a fence. The witness stated that on 19th January 2022, page 2049 of the transcript. The SBO noted that the witness deviated from a previous statement
Your Honor, we're in public session.
Thank you. And Defense Counsel, I think that you can reread the part of the statement just to make this session as public as possible.
I will, Your Honor. I will. And I start again. But do you remember saying that indeed there was a fence on one side at the perimeter of that compound? And he replied, every house has a fence, or part of its yard surrounded. I'm not very accurate how many part was fenced, but the house was not. The family was not living there, so I did not pay much attention to the surrounding of it or to a building or a fence. It might be that there was a part of a fence still on. It was, and it burned down. For me, it's not important. Maybe for you it is, but for me it doesn't make any difference. The 19th of January, 2022, page 2050 of the transcript, Your Honor. Our general conclusion about this witness on this aspect is that the witness is not conclusive about the fence around the yard, and therefore no conclusion to that extent can be drawn from this witness. But the defense witnesses then, at least 5 defense witnesses, Hadri, Chanoli, Krasniqi, Ayeti, and Humoli, were able to describe the general location of the Slash compound. They describe it as an open area. None of them spoke about a fence, gate, entrance around the compound, or any kind of gate giving access to the compound. I get to the aspect of the yard of the compound, Your Honor, and in this particular aspect I would like to ask the court officer to bring up first the DSM 00436. It is a picture that we know well, Your Honor. We have seen it many times. And this is what the aerial picture looks like. Maybe we can enlarge it a little bit so that we can see. Thank you very much. And then I would like to bring up REG 00013. Thank you very much, Madam Court Officer. And here we see the same aerial photo. We've seen this one also before, with all the structures that are there on that area visible. I recall that these pictures were made in 2006. I mean, not the aerial photos, but what is in the case file on the Slash compound, so to speak. The next one that I would like to bring up, Your Honor, is a photo with DSM 00412. And maybe we can put this one next to the previous one. Madam Court Officer, I'm sorry, but if that would be very helpful, so that we can see the two next to each other. And what we basically want to see here, they fit more or less next to each other. The defense made a 3D recreation of this area, and that would a little bit be like this, and we see a little bit better the structures as they would have most probably looked like. Your Honor, then I would like to ask the court officer to bring up the next 2 slides, which is DSM 00412. Is that correct? Excuse me, I make a mistake, Madam Court Officer. It's DSM 00035. 00035. And next to that, yes, thank you very much, Court Officer. And next to that, DSM 00424. And with these pictures, I would like to discuss the yard. This is based on our own measures that we made at the time on the location. We have done this and made even a kind of a scale map, and as we can see, the distances, obviously they are approximately, but we are sure that we made accurate measurements, Your Honor. The yard then. What does witness 3593 say? Witness 3593 said nothing about the location in general, but he was questioned about the yard upon his release. And the SBO asked, "You told us yesterday that when you were released you saw many people outside. Is that correct?" And he replied, "I told you yesterday that when I went out to the yard, I saw there many people, and we all just wanted to run away as soon as we could. That is why I did not look around. I was not interested to look around. I was just concerned about my own life." 21st of September, page 516 of the transcript. Earlier on, we have already quoted the witness as saying that he saw at least 60 people in the yard, both in civilian and military clothes. He did not in any manner further describe the yard itself. That is what he said on the 22nd of September, page 608 and 609 of the transcript. The conclusion about this witness regarding the yard, Your Honor, is that the witness did not look around and basically was not interested to look around, and therefore he was not able to describe the yard. And our general conclusion is that while not being impaired in his vision anymore, the witness could not provide anything about the yard, as there are at least 9 buildings around the yard, of which one was standing in the middle of the yard. The witness must have been able to see at such short distance these buildings. Therefore, the defense is of the opinion that the witness was kept in another location. Witness 1679 said nothing relevant to this topic. 3594 then. 3594 described he had a possibility to go into the yard without a mask, but did not really describe the yard itself. He had been given the opportunity to use a toilet outside the barn where he was kept. He stated that on 12th of October 2021 on page 1074 of the transcript. Once again, regarding the yard, the witness, as earlier quoted, said, "I saw this space and I saw that there were 2 houses with that compound. I do not know who the owner of the house was, but there were 2 houses opposite each other. I saw 2 houses." And to be clear, the witness described it as he went up to the room where he had a conversation and a coffee. Upon a question of the presiding judge, 1 or 2 houses? And he responded, "With the house where we were, there were in total 2 houses. 13th of October, page 1176 and page 1177 of the transcript. Any further description was not given by the witness, but at least he was the one that could say something because he was without any mask. Then witness 4669, Your Honor. Upon a question of the presiding judge regarding what the witness saw around when he went outside the barn where he was kept, the witness responded, "Nothing. just a field, a green field, and a toilet. This is how the witness remembered it. The witness stated on a question posed again, "Did you see any buildings?" The witness replied, "No, only the one I exited to go to the toilet, and there were buildings near that one around it. And we were not allowed to look on our right or on our left. We just had to go straight and then back." The judge continued, "And the building near the one that you were exiting, how many buildings were that?" "About 2 or 3 very close to each other, almost attached to each other, and there were others a bit further, according to the configuration of the terrain." It's 11 November, page 1575, page 1576 of the transcript. He said, Your Honor, that he left without looking back when he was released. He did not remember whether there was a gate to the yard to go inside. There was only a door to the building of the barn. And the witness stated this on 11 November, page 1549 of the transcript. The conclusion for both witnesses 3594 and 4669 is the following. 1. Both witnesses described maximum 2 or 3 houses that they saw in or around the yard. 2. As we said earlier, 03594 spoke about the haystack in front of the barn. And 3. 03594 spoke about an old house in the opposite side. He did not give any further description of the yard. Our general conclusion is the following. With 9 buildings around the yard, of which was 1 in the middle of the yard, as we have seen on the previous photo, and on such short distance, the witness should have been able to identify these. Based on their description, these witnesses are speaking about a different location. Then defense witness, at least 5 defense witnesses, Your Honor, Hadri, Kanoli, Krasniqi, Ayeti, Humoli, were all able to describe the general location of the Salih compound. They describe it as an open area. None of them spoke about any fence, gate, entrance around the compound of any kind of gate giving access to the compound. All of them spoke either about crossing the yard, staying in the yard, in particular witness Fatmir Humoli, who spoke for hours with his family in that very same yard. The witness Humoli explicitly said that he spoke with his family in the yard, that is, in the yard between the buildings on the picture. I quote, that is the picture ERN DSM 00119 up to 00133, attachment number 2. And he said it was in the yard that he met his family because it was not possible to meet elsewhere. He would do that even for hours. And having said that, Your Honor, the witness stated that on the Monday, 4th of October, 2021, page 915 of the transcript. Excuse me, Your Honor, my mistake. Transcript of 2nd of February, page 2405 and 2425, and the transcript of the 1st of February, page 2366. Your Honor, then I would like to go to the number of structures. And maybe we can go back to the previous photo that we showed, which is REG 000013. Exactly, Your Honor. The number of structures. (3593) spoke about 3 places. The first place, Your Honor, where he was kept was where he was put inside, which was a barn shed for animals no more than 5 meters big, page 403 of his testimony, 20 September 2021. The second place was when he was dragged outside to another place 5-6 meters away from the place where he was initially brought. In the second barn is where the beatings started. The second barn was covered with something, he said. The second barn was covered with something. Page 408, 20 September 21. The third place was the place where he was taken 15-20 meters further away. He was taken there with the alleged murder victim, of the alleged victim of the murder. As discussed earlier, he had on this occasion a sack over his head. That's page 416 of 20 September 2021. And it is in this last barn where he was kept for the rest of the period of his detention. He made a sketch of the place where he was kept. And we can see in the document with ERN number 061012 up to 06015, that sketch. We will get later to the topic of the description of the barn itself. But it is important to know that at this point, the witness tried to sketch how the place of detention looked like. Upon his release, he did not indicate anything further, as we have discussed earlier. Witness 1679, he mentioned only one building, which was the building where he was kept. He did not describe any other building. He clarified that as he was interrogated, he would go to an upper floor. W1679 was taken initially to the location while was having a sack over his head. As he was interrogated and taken upstairs, he would again have a sack over his head. This was not through internal steps, but through external steps, Your Honor. And the sketch that he made indicated only 3 houses in total, Your Honor. I would like to go briefly, Your Honor, in private session.
Madam Court Officer, could you bring us into private session, please?
For the record, Your Honors, we're now in open session.
Thank you. You have the floor, defense counsel.
I pick up where I left, Your Honor. He said lastly in the transcript, this was not through internal steps, but through external steps. And the witness said that on Monday, 4th of October, 2021, 915 of the transcripts. In other words, the witness did not say anything on other buildings, but stated only that about the building in which he was kept during the 18 days of his detention. Your Honor, I would like to just at this point ask whether we can, we have this picture still, and then I would like to ask the court officer to show the next photograph, which is SPOE 00128-410. And with this picture, if we can leave it for a moment, I would just like to mention the building which, yes, that is excellent, thank you very much. If we can move the other picture a little bit more to the left, that would be very helpful. The underlying photo, yes, thank you very much. We see building number 7, and we see structure number 8, or better to say 9. The defense believes that with the photo on the right-hand side, we can see that structure indicated with number 7 standing over there. That is the position of the defense, that structure over there indicates number 7 on the photograph, which is on the left side.
Defense
Now-
counsel, for my understanding, in order for me to get it right, on the structure that you are indicating with number 7,
Yes,
on the
Left.
picture with reg 00013,
yes,
you say that on the other picture with the number ending in 128420 red, with the roof that is damaged, that is structure number 7.
that's right, Your Honor.
Okay.
And in order to clarify that, on the right photo we can look past that structure, that demolished structure and the tree. There we look at something that looks like the part which is on the left side indicating number 9 around there. And if we, Your Honor, would take out the right picture, court officer, and take the next photograph. And that is, to be clear, SPOE 00128-410. That is the ERN number. That is not the, this is, we need photo A2 in this case, Madam Court Officer. And that is indeed not 410. That is, I have it here. That is, sorry, that is the ERN number 00128-389. And
Wait,
this, to be clear, it is photo A2. We believe, Your Honor, we think, and it's our position, that on the left, looking at the left photograph, the position where the photo on the right is taken is most probably from number 9, position 9 of the photo on the left. So position 9 would be the position, more or less, from where the photo which is depicted on the right side, photo A2, would be taken. And that is what we wanted to clarify here.
Okay, and for my understanding again, would then the number of the building on the right picture,
Yes.
which number would that get on the picture on the left?
Yes, the demolished building, that is the building that is clearly demolished on the left
Yeah.
side, is number 7.
Yes, and then the building on the right-hand side on the
Is
same
most
picture?
probably building number 6.
Okay,
That is the position.
okay, good, for the record.
Thank you very much, Your Honor, and thank you very much, Madam Court Officer. I would like to continue with the witness 3594 regarding, once again, we're discussing all the number of structures and so on.
Defense
359
counsel, sorry, and with pointing out
Yes.
what you just pointed out, what is the point you want to make for us to take into account?
I get to that in a little bit later stage, Your Honor.
Okay, okay, because you're
with,
leaving me
when I-
curious. I would like to see the whole picture.
Yes. Well, I can say already, if witness 4600, as he stated, has delivered anybody, and as we know, 4600 stated that he would have handed over the alleged victim of the murder at a particular point near the slash location. He pointed that out at some point, and he spoke about a particular point. And what we are trying to say with this, that taken from that point, or more or less that point that that witness indicated, it would be impossible, it would be really impossible to see the houses on the right side of the compound. And if we go to the, if we take the last photo again, the structure, and that is the one with all the numbers.
Madam Court Officer, do you need a number?
It's REG, it's the same, this one. And if we maybe enlarge it a little bit. Yes, that is a little bit to enlarge it. And we can see the number 9 well. Well, anyway, seen from position 9, it would be impossible, thank you very much, Madam Court Officer. Seen from position 9, we believe that the structure number 7 clearly blocks the view to any of the right-hand side building, in particular the numbers 2, 3, 4, and 5. That part is not visible, simply not visible. And the height of that building, and it is a slope there. We can see once again on picture 820. Madam Court Officer, if you would please produce once again 00128-410. Thank you very much. There we can clearly see how that it is a slope terrain which is going down, which indicates that if you are standing there at that position number 9, that demolished building as it is to be seen simply blocks any view at all towards the right part of the slash location.
Can you repeat this explanation?
Yes,
just
Your Honor, I will. If we look the demolished building and the tree, and we look precisely in between,
Yes.
we believe that we see there the other position that we just indicated. That was position 9 on the previous photo. Taken from that position, but this picture is clear because we can see a little bit the height of this demolished building, what the height is. Plus we can clearly see that the terrain is slope, is going down. That is what we want to point out with that. So in any case, a person standing on position 9, more or less, his view would be blocked due to the fact that there is a building standing there, and that is building number 7.
Thank you for your clarification.
Mm-hmm. If there is something unclear, then I really can clarify it at this moment the best. If there's any other question regarding it?
Yes, thank you, Defense Counsel. But then, if I understood you
Yes.
correctly,
Yes.
if you are on position 9, which, by the way, looks like a fence, huh?
Yes, that looks like a fence, a remnant of a fence.
Yeah. Then, if you're on position 9, then the only buildings that you would see would be 10, 11, and 12. Or is there something I don't understand?
10,
Can
11,
you
and 12?
please wait? Shall we bring back the other picture and
Sure.
put it next to it, and then we can confront it? Please, you
So-
can re-ask the question.
Yeah, so if I understood you correctly, somebody entering through 9,
Mm-hmm.
that's what you're saying, if I understood correctly,
Yes.
would see the buildings on the left, 10, 11, and 12, but would not see, because of building 7, maybe also because of the tree, would not see 2, 3, 4, 5, 6. Do I understand correctly?
You understand that correctly. And to be clear, 4600 explained that he saw Salih Mustafa on the veranda, and that is the only place on the right side where there would be a veranda. So that is the moment that he apparently saw him on at those structures.
Okay, so your position is that actually 4600 could not see Mr. Mustafa because, according to what you're telling us, Mr. Mustafa at that time would have been on the right and not on the left.
That is exactly what the witness 4600 stated.
Okay.
Thank you very much. With that explanation given, Your Honor, I continue with let me see, 3594. I just want to say that, again, this witness speaks only about 2 houses. Upon a question of the presiding judge, was it 1 or 2 houses, the witness responded, with the house where we were kept, there was in total 2 houses. And then coming to witness 4669 on this issue, asked about any surrounding building from where he was kept, the witness stated as follows: "No, only the one that I exited to go to the toilet. There were buildings near that one, around it, and we were not allowed to look on our right or on our left to where we had to go and come back. About 2 or 3 very close to each other, almost attached to one another, and there are others a bit further, according to the configuration of the terrain." The witness stated this 11 November 2021 on page 1542 and 1543. The general conclusion regarding the number of buildings of the SPO witnesses 03593, witness 1679, and witness 3594, and witness 4669, is that all 4 were not able to identify and describe buildings at or around the place where they were kept. If they would have been detained on the Salih compound with 9 structures, some of them big structures, and one even in the middle of the yard, they could not have missed those buildings. Therefore, it is in the opinion of the defense that they were kept in a different location. Then, Your Honor, the building where the people were kept, the barn. 3593, Your Honor, according to him, he stayed in the following places that he was taken into detention. Initially, he was put a sack over his head and then was put in a barn where the sack was removed. That is place 1, page 403. Then he was taken outside to another place, place 2, where the perpetrators started to beat him. That is page 406, 407, and page 408. And then lastly, the next day, subsequently he was taken back to place 1, where the other person had remained. That is page 406, 407, and 408. The next day, he was moved to another place, and that is place 3, where he was eventually kept for 18 days. In this place, he was moved together with the alleged victim of the murder, and he found in that last place 2 or 3 other people. He summed it up as 5 people in total. That is page 418 and 419. Now I will not say how he described place 1. He described it around 5 meters. This is all the testimony, to be clear, on 20 September 2021, the page numbers that I noted. Place 2 was also not about, was about 5 to 6 meters away from where he was staying. And he says there were wood, all different sorts of stuff there, and it was there that they started to beat me up. He continued to describe this place, and he said, place 2, he answered to the question of the SBO, that it was covered with something. I could not exactly tell. I can't exactly tell you because I was not looking. It was a dark place, as he was unable to see who actually beat him. The people used torchlight every now and then, and that is 20 September, page 410. He continued on this topic, and it was some sort of place. There were no walls, but there was just a cover. And I do not know anything else because it was dark and I didn't see a thing. I didn't see a thing at all. 21st of September, page 562 of the transcript. Again, a question of the SBO. Did the place have any lighting or windows? No, nothing at all. The witness stated that 20 September, page 417. Your Honor, this witness then described place 3, place 2, around whether there was illumination or a window. Upon a question of the defense, he replied, speaking about the barn where he was kept all the time, whether there was any window, and he replied, no, it was not closed, it had a peak. It was open, it was some sort of place, there were no walls, but there was just a cover. And I do not know anything else because it was dark and I did not see a thing. I didn't see anything at all. I do not know whether they had any electricity or not, but it was dark. I couldn't see the roof. It was dark. They did not allow me to see. I didn't see the roof at all. 21st of September, page 562 of the transcript of this witness. Then he described with the third place, and the witness explained, yes, we could not sleep because the upper part was covered with wood. The SPO asked, are you saying that the ceiling of this place where you were staying was made of wood? He answered, they were simple wooden planks. Up there, they used to keep food for the animals, but they were using it as a room. The witness stated that, 20 September, page 476 of the transcript. A sketch, Your Honor. He made a sketch. Apart from the witness that he made a sketch, which can be seen at SPOE 061012, the witness explained it in court when he was confronted with the drawing himself. On the 21st of September 2021, page 518 of the transcript. He was later on even confronted with a photograph of the outside of what the defense calls the ODA building. The ODA building, I'll come back on it, what we call the ODA building, but it's basically the building with the upper part and the lower part that we have seen. I will explain that later, which building we indicate as the ODA building. I can do it now already. Yeah.
Almost time for lunch break, so
Yes.
maybe you could say you could look for a natural moment to interrupt
Yes,
your
yes.
submissions.
Your Honor, that's exactly what I'm doing. Maybe we can bring up the photo once again, the photo with all the numbers on it. And then we will conclude this witness. Thank you very much, Madam Court Officer. Building number 12 is what we call the ODA building. The building number 12 on this picture. Your Honor, the conclusion, the witness identified through a photo, and that photo is SPOE 00128-392 of a building that he marked with number 2. I will give the ERN number. It's easy to review that. ERN 100967 with an official note attached on the 3rd of June. That is the other identifying method that was being used for this witness. Okay. Now I come to the conclusion for this witness, and then I think that would be a natural moment to stop for the lunch break, Your Honor. If you allow me, this witness, Your Honor, described only the inside of a structure, but he does not describe the outside of the building, as he was unable to see this since he was put a sack over his head. Number 2, as we said earlier, witness 03593 spoke each time about the inside of a place, never the outside. 3, nevertheless, he was confronted with a photo of the ODA. 4, 3593 therefore can never identify the outside of the building based on a photograph. Based on the sketch is my next point. Based on the sketch he made and comparing that with what he identified through photo number 2. Photo number 2 is SPOE 00128-392. Based on the sketch he made and comparing that with that identified building, number 2, it confirms the position of the 4 defense. It confirms the position of the defense that he was in no position to give any description of the building on the outside, because his head was covered all the time with a sack, even when he was transferred. And as I said, he only described insides of the building. The general conclusion, and then I will conclude it, Your Honor, this witness did not make a reliable identification of the building in which he was kept. The witness was unable to identify an outside of a building, as he has never been able to see where he went when he was transferred to the place where he was beaten. The sketch and the photo that was shown to him cannot be reliable and have no probative value whatsoever. Showing him a single picture, especially when the place was never described from the outside by the witness, showing a witness in such circumstances a single photo is suggestive and leading. In such case, the witness should have been shown multiple photos of similar building from which he could have made a choice. Therefore, his testimony to this aspect and the evidence relied upon by the SPO is not reliable. Thank you very much, Your Honor. I would like to conclude for this moment and then after the break continue. Thank you very much.
We will resume at 2:30.
Microphone, please.
All rise. All rise.
Please be seated. Welcome back. I call the appearances, but I see the same composition for the SPO, same composition for the Victims' Counsel, and I see nodding on my right-hand side, and the same composition at the left-hand side for the defense team, and Mr. Mustafa is also present. Very well. Good. Defense Counsel, you may proceed.
Thank you very much, Your Honor. We will continue with the discussion of the witnesses. And we would like to ask the court officer to bring up ERN REG 00001 0013. Excuse me. Your Honor, we continue where we left over, and we would like to discuss the witness 4600 on this occasion.
Microphone, please, Defense Counsel.
I need to sort out one thing, sorry.
Please proceed.
Thank you, Your Honor. Your Honor, discuss witness 4600. And with this picture in mind, I would like to quote what the witness said, witness 4600, on the 23rd of September 2021. And I quote from the transcript, that is page 732. Yes, we were at the gate, says the witness. And the question is, and I think you may have told us, but if you could repeat, what's the distance by and large between the place where you were and where Commander Salih was? As I said before, I don't know exactly, but about 20 to 30 meters, I'm not sure. So yes, 20 to 30 meters. Now, is the question, now, was that sort of was it a balcony? Did you tell us it was a balcony where Commander Salih was standing, or some sort of a balcony? And the answer is yes, some sort of balcony. He came out of one room, as I said. This balcony connected 3 or 4 rooms. I do not know how many. He came out of this room here. There was a door there, and he came out of that room, that door, and he greeted us. And the question, was there a bit of an elevation from the ground to this balcony where he was standing? Or was it at the same level where you were? No, it wasn't, because there was an uphill area, not too high. The balcony was not much higher than the ground level. And that's where Salih was. Your Honor, if I may ask the court officer to bring on the screen DSM 00412. This is the 3D representation that the defense made. If you could zoom out slightly, Mrs. Court Officer. Thank you very much, because and enlarge it a little bit more. Anyway, it says that it was based on the blow-up fixture of the following aerial. Of one of the aerial photos that we know, and that is written under it, that is SPO 00213478. So that would be the configuration of that as it appears to look like that. If we go to DSM 00388 once again. Once again, actually, it's we have more or less the same representation, and with the indicative measurements that the defense made at the time of the location of the slash compound, as we know. Now, here, as we can see, the structure which was demolished, which we spoke earlier about, is not in this representation. However, if we go to DSM, I would like to point out here to the family house to the right. I will make some comments about that. And if we go to DSM 00436, that's right. And if we could enlarge that to the great extent. Yes, thank you very much. And we go to the right. And we view the part on the right side. There obviously we see on the right side the building on the very right. It's a large building on the right side under, with the demolished building that we saw on the earlier photo. And on the top right, we see a house, or a room at least, without any roof on it. And it is that particular house that I would like to point to the panel's attention. If the court officer would please show DSM 00392. This is what the defense made. It is a view uphill from the map that we made, and it is pointing in the direction to that house as we have reconstructed it on the basis of the testimony of Selahattin Krasniqi. As we know, Selahattin Krasniqi was the one who was living there and whose family created that house. On the basis of his statement, we actually interviewed him on that and created a map in the beginning with him. And regarding that, maybe if the court officer can put up the
Please, defense counsel.
Yes.
The number of this building, for the record, that would be, according to the photograph that you have been showing us with all the numbers indicated by Mr. Krasniqi.
according to that photograph with
Yes,
all
we
the
have
numbers?
a photograph with all numbers, and I
Yes.
would like to make a link between this photograph and
Yes, that would be the building which on that photograph with the numbers is 2, 3, 4, and 5.
thank
2,
you.
3, 4, and 5. And if we, as we discussed this building with Selahattin Krasniqi, he gave an indication of how that configuration of that house was, and that was more or less to be seen at DSM 00406. Yes.
Defense counsel, I would have a preference, if it's possible, taking into account how big this picture is, but to have also the picture, the aerial picture with
Yes.
the different.
Okay.
I think that
Okay.
would
With
help
the-
us in understanding better what you are.
Yes.
Showing.
And that is with the numbers, I
Yes, yes,
assume.
that's
so, court officer, yes, thank you very much. So that building consisted of, in total, 4 rooms with the dimensions given on that photo as we see it on the right side, roughly, and that was given also, that was based on the testimony of, what's his name, Selahattin Krasniqi. As we can see, these rooms, they come all out on a balcony, and that is obviously the single building which has a balcony or a veranda or whatever we call it on the compound. If we take a look at the last photograph, and that would be photo A1. Photo A1, that is SPOE 00128-388. And if the court officer would be so kind to put that one on the screen. And if we could zoom in on those buildings, and then in particular the building to the right a little bit. Yes, this would be fine. Then it is the defense position that there is nowhere to be found a balcony on this building whatsoever. And therefore, Your Honor, we believe that witness 4600, with whatever he stated, could not have been talking about this building, because there was no some sort building. As I repeat his testimony, and that is the testimony of the 23rd of September, page 732 of the transcript. Yes, some sort of balcony. He came out of one room. As I said, this balcony connected 3 or 4 rooms. I don't know how many. He came out of this room there. There was a door there, and he came out of the room, and then he greeted us. And then it continued. Was there a bit of an elevation from the ground to this balcony where he was standing? Or was it at the same level as you were? No, it wasn't, because there was an uphill area, not too high. It was not much higher than the ground level, and that's where Salih was. So, Your Honor, it is the defense position that witness 4600, his testimony regarding seeing Salih from the position that he indicated, and I should say he indicated that not only one time, but he indicated it in fact 2 times, as in his earlier testimony he has drawn a map of the situation, and that map indicated that he was viewing to the right side of him if we take him at the position of the gate. And that, Your Honor, he stated in his testimony when he spoke with the special prosecutor at the time, Mr. Carney, and I am not sure whether I have that document now right here, but I think I have. Yes, I do, Your Honor. He drew a sketch of the situation, and he did that, Your Honor, when he was interviewed. Document 072908 until 072914 RED1. That is where he has marked it, and the exact number of that particular sketch that he made is, to be exact, ERN 072909. And with that, Your Honor.
Are you intending to show that on the screen?
No, Your Honor.
But I think I would like to have it on the screen just to understand better.
I don't think we have it on the exhibit numbers that we have given. I just refer to the.
To be honest, for me it's not clear now.
Okay.
You're describing it, but
Yes. Yes. Well, I can maybe do something about it, but let me first explain what the witness says about it.
okay.
He says in his statement, that is the transcript of the 23rd of September 2021, he says, On the questions of my learned colleague, he says, the question is, now do you remember sketching this during your SPO interview that took place on the 21st of January 2020? Yes, I remember it. Now in the bottom, slightly left side of the sketch, there is an arrow. Can you see that? Yes. Can you tell it what it depicts that part of your drawing? There are two arrows. The arrow from the road to the gate, and then the other going inside into the yard. Question, yes, I believe that's a number 1, but it doesn't look like an arrow. But could you tell us, and then the answer of the witness is, no, that's an arrow. Okay, that's okay, says the prosecutor. Could you tell us what that drawing represents? What is it that you drew there? I tried, and that is indeed that document, I tried to depict here that when you come from the left side on this road and you stop in front of the gate, that's what the first arrow depicts. And then the second arrow depicts going inside, and that's why I put that arrow there. Thank you. I apologize, says counsel. Thank you. The question is, thank you. I apologize for mischaracterizing your sketch. Now, you see what appears to be a number 2 to a rectangular drawing on the right-hand side. It's on the center, actually, of the sketch. Do you see that? And the answer of the witness is yes. And the question is, can you tell the panel what that represents there? Well, this was a building, a single-story building, an old one, up to these lines, and then you can see in the sketch there was some sort of a porch there. And there were rooms, 1, 2, 3, 4, I don't know how many there were, and all the rooms had doors that came out to this porch. Does this drawing depict the place where Commander Salih greeted you? Yes. And where is the place in the sketch where Commander Salih greeted you from? From this part there. From this part there. Thank you very much. You were standing. Can you also mark with the same pen the place where you were standing when the exchange happened? Yes, we were at the gate. Well, and then I will continue. The question is again, and I think you may have told us, but if you could repeat, what's the distance by and large between the place where you were and where Commander Salih was? Answer, as I said before, I don't know exactly, but to 20 to 30 meters, I'm not sure. Yes, 20 to 30 meters. Question, now, was it a balcony? Did you tell us it was a balcony where Commander Salih was standing, or some sort of a balcony? Answer, yes, some sort of a balcony. He came out of one room. As I said, this balcony connected 3 or 4 rooms. I do not know how many. He came out of this room. There was a door there, and then he came out of that room, that door, and he greeted us. And I stop at this point with this witness because I have already read rest. Your Honor, in sum, to be clear about the witness 4600, and as it is the position of the defense that from the place where he would have been standing, he would not have been able to see Mr. Mustafa, if Mr. Mustafa was there at all, I should say. In any event, there was clearly blocking and demolished structure from his position from where he would not be able to see him. I continue with the next witness, Your Honor. It's witness 1679. He's another witness that I will discuss regarding the fact whether he is able to identify any buildings, any structures on the location. According to W1679, he spoke about the barn where he was kept, and he stated about that.
Defense counsel,
Yes.
sorry to interrupt you. I think we can take down the picture.
Yes, Your Honor. Yes, we can take them all down because we don't need them anymore. According to W1679, he spoke about the barn where he was kept. He stated, for what I remember, it was a building made of stone. There was a wooden door, there was some hay, dampness. And then the witness, that is 4th of October, page 882 of the transcript. Then the cowshed he described as follow. There were no animals, but you could tell that it was a cowshed. You could see that because I have seen in the past such locations, places where cows are kept. So could you tell it could you tell it was a cowshed? Upon question whether it was locked, yes, it was a wooden door that we would use to come in and go out, and where there were these wooden posts, beams. The witness stated that again, 4th of October, page 919 of the transcript. The witness 1679 was asked about the cowshed or the barn where he was kept, and he gave the following answer. The question was, could you describe that place for us, that cowshed or barn, whatever we want to call it, in dimensions? The witness answers, it was not a big place. I don't really know how big exactly. It was normal ground. There was hay on the floor. It was damp, stone walls and beams. I don't really know how big it was. Perhaps it was as big as a normal room. About whether he was able to touch the ceiling, the witness stated, I do not remember, I don't know. At the time I was smaller, and I think perhaps I wouldn't be able to touch the ceiling then. And about the dimensions inside the barn, the witness says, I don't know, sir. I wouldn't be able to tell you. And lastly, about whether there was a window, the witness said, I don't remember. As far as I remember, there was no window. There was just a door, a wooden door. And there were some spaces where you could see the light between the wooden slats. But I didn't pay much attention to these things. And it is the 5th of October, page 982 of the transcript. Lastly, Your Honor, the identification through photos. The witness identified through 2 photos, SPOE, that is 00128-388, and SPO 128392, of buildings he marked with number 2, and that is in ERN 100803 and 100805, with a special note attached. About the inside of a place, never the outside. The description of the outside that he gave was extremely limited. Four, nevertheless, he was confronted with 2 photographs of what we call the ODA of the compound. 5, from the statement of the witness gives not any distinctive description of the external part or look of the place where he was kept. In addition, the witness failed to give any description of the yard. The description of the interior of that basement where he was kept does not provide anything specific that can point to the internal of the basement of the ODA building or another building at the scene of the compound. It is not a distinctive description of a basement, but could be any basement in the area. 6. W1679 therefore can never identify the outside of the building based on a photograph. 7. It was the first time that he was there, and he has never been there since. 8. The sketch he made, that's ERN 060694, dated the 5th of June, and comparing that with what we know about the compound, it is impossible to make something out of this. It is clear that it does not in any manner anything to that can be seen. It does not reflect in any manner anything that can be seen on the compound. Lastly, Your Honor, on this point 9, therefore the identification through 2 photographs, the photographs 00128-388 and 128392 of the ODA building, it confirms the position of the defense that he was in no position to give a good identification of the building where he was kept. Your Honor, this witness did not make a reliable identification of the building in which he was kept. The witness was unable to identify an outside of a building, as he has never been able to see where he went when he was transferred to the place where he was beaten. The sketch and the photos that were shown to him cannot be reliable and have no probative value whatsoever. Showing him a single picture, especially the outside of the place, was never especially when the outside of the place was never described in a distinctive manner, showing a witness in such circumstances a photo of a single building is suggestive and leading. In such case, the witness should have been shown multiple photos of similar buildings from which he could have made a choice. Therefore, his testimony in this aspect of the evidence cannot be relied upon by the SPO. It is therefore not reliable. Then, Your Honor, we go to the witness 03594. He described the building where he was kept as a 2-story house. Below that house, in the lower part, there was an old door. They opened the door and I entered the room. It wasn't a very big space, I would say, not very small, but neither very big. It was an area where animals are kept. There was a small window in the lower part. There is one door and a window. The witness stated that on 12th of October, page 1039 of the transcript. There was no bed there. There was no discussion of a bed there. They brought us some hay because they had some hay outside of the building, and that's what what we did, is that we laid that down, and we had some blankets as well. That is the 12th of October, page 1073. Then, whether there was daylight in the barn. Could you see any daylight in the barn? Yes, because there was a window. There were 2 parts, and there was enough light, daylight, coming into the room. It wasn't a window with glass. It was covered with timber, with wood, but it was an open space where you can look through, or it was closed because of the timber. But that was the question, excuse me. But was it an open space where you can look through, or was it closed because of the timber? The answer was there were enough openings for daylight to come in. Those were old wooden planks. You can imagine it was a window for a place where animals were kept. And was it possible to look through the window from the barn? And you could watch outside from the barn through the window? And he said, no. This is all the 13th of October, page 1185, 1186 of the transcript. The conclusion regarding this witness, Your Honor, the witness describes the building in general terms, even though he was not impaired in his observation by a sack over his head. As we said earlier, spoke nearly most of the time about the inside of a place, but gave no particulars about the outside. The description of the outside that he gave was limited, not very descriptive in the sense that it can be compared to any of the photos. He described a single house from which on the opposite side would be one old house. The conclusion for this witness, Your Honor, is that he did not make a reliable identification of the building in which he was kept. Then, Your Honor, witness 4669. The witness stated concerning the barn was a sort of room, big inside, something like a stable. There was something like a trough, a feed trough for animals in there. It was made of wood. The walls made of wood and earth. The wall had cracks, so we could see outside. The walls were built of wood, hay and mud. And I remember it was always dark. There was a window, but it was closed, so the light could not come in. The transcript of 10th of November 2021, page 1430 of the transcript. And about the conditions of the barn, Your Honor, the witness stated whether it was possible to look through the window from the barn as follow. No, not according to the witness, through a window, but he was able to look through the cracks of the wood of the wall. The moment in time that the witness was kept inside, there were persons in the surrounding area, because the witness could see their movement through the cracks of the barn. He could see the silhouettes of those persons. He could see tens of people dealing with different activities. The witness stated that on the 11th of November, page 1532 of the transcript. Asked about how the barn looked and the condition of the barn, the witness replied that it resembled a stable and that there was some hay here and there. He smelled and saw animal excrements. That is 11 November, page 1545. Lastly, the witness stated about whether the door of the barn was closed. It was a wooden gate or door. It was made of wood and planks, like wooden planks, and it was locked from outside, like our traditional doors. They would lock it either with a lock or something. I did not see that. It was sort of grayish black color. 11 November, page 1547 of the transcript. Your Honor, in the submissions regarding the panel's question, the SPO filed a document. That's F00471. In that document, page 3, the photograph SPOE 128388 with a blue circle is shown on the top of that page. However, the witness stated during the testimony that, and I quote, "Mr. Witness, there's a dark blue circle around two buildings. Is that place encircled by yourself?" He answered, "The drawing? I do not remember that I have done that, so probably someone else has done that." He asked first on whether this was the place, and probably they have encircled that place. The transcript, page 1471, transcript 10 November 2021. The witness was shown in his interview with the SPO at the time. SPO 128407, because there is no indication by the interview which photo he exactly encircled. The conclusion about this witness, Your Honor, is that the witness described only the barn, and based on his description, it might have been recently used for animals. 2. The witness described the building in general terms, even though he was not impaired in his observation by a sack over his head. 3. The description of the outside that he gave was limited, not very descriptive, in the sense that it can be compared to any of the photos. And 4th, he stated that he did not believe he encircled anything on a photo. Our general conclusion is that the witness did not make a reliable identification of the building in which he was kept. Your Honor, I will then move on to...
Defense counsel?
Yes?
We went into a private session this morning, and I would just like to remind you, without going into private session again, of what we discussed then with regards to
Yes, Your
what
Honor.
can be said or not. Yeah?
Okay. I would like to cover the people, what we would call the interrogators, and what was said about that. And then I would like to first go to witness 03593. The witness stated that he was interrogated by the accused. This was approximately 6 or 7 days before the 18th. 2 soldiers had sent him to the room upstairs. There was this room upstairs, and the accused started asking questions to him. And so he asked questions like, "Who is a thief?" The witness stated that on the 20th September 2021, page 419 of the transcript, and I would like to ask, Your Honor, to go into private session
Madam Court
for a
Officer-
brief moment.
Madam Court Officer, could you bring us into private session, please?
Your Honor, we're in public session.
Thank you, Madam Court Officer. Defense counsel, please proceed.
Thank you very much. This witness, Your Honor, it is only in 2021 that he starts to use the name of the accused. He does not even want to pronounce the name of the accused, but he never mentioned anywhere else ever the name of the accused. The conclusion regarding this witness, based on his testimony, it cannot be proven that a redhead, that is the accused, that interrogated him. Then witness 1679. The witness claims that he was interrogated by Commander Salih. That was upon his arrival at the time that he was taken from the school building to his later place of detention. 4th of October, page 867 of the transcript. The conclusion from the testimony of the witness it cannot be proven that on the day of the arrest of the witness, the commander was the one who interrogated him or who introduced himself as Commander Salih. Then witness 3594. This witness did not mention the accused at all as one of the interrogators. And witness 4669, he was only interrogated one time on the third day of his arrival at the place where he was kept. The interrogation lasted 20 minutes to half an hour, including the beating that took place on him. At one point, 2 females came. They just stood there near the others. His beating took place after the co-detainees had been interrogated or beaten. And who he interrogated this witness? While being interrogated, he never noticed anybody being in command. There were 2 persons that would question him, about 17 years of age. There were 2 other people that were standing close to these young men, so they were kind of readiness, if need be, to intervene. So there were 4 persons standing around him. He did not know the people who interrogated him. The general conclusion regarding this witness, Your Honor, is simple, that he did not mention the accused at all as one of the interrogators. Your Honor, may we go... I have a reference number of the person that we discussed in a private session. This is maybe the moment to give that a number. Should I do it in an open session? Okay. The
ERN number is not a problem.
okay. So the ERN number is SPOE 00127751 until SPOE 00127752.
Thank you.
Yes. Okay. Your Honor, the number of people held in detention. I will start with witness 3593. According to W3593, he mentioned several individuals that arrived in the place where he was held. It developed over the time that he was there. In place, he met only the alleged murder victim. He was kept there. That is the first place where he arrived, excuse me. He was kept there for 1 or 1.5 hours. And then he goes back, he goes to place 2, and he met nobody because he was beaten up there. He goes back to place 1, where, once again, he met the person who is allegedly murdered in this case. And then he goes to place 3, again together with the alleged person that is murdered in this case. And initially, upon arrival there, he saw there 2 or 3 people that were already there. That is the testimony of the witness on the 20th of September, page 416 of the transcript. So they opened the door, and I do not know, because we had the sacks over our heads. So they pushed that inside, they removed the sack, and it is then that we saw 2 or 3 other people. So this is how we got there. The witness described that on page 419 of the same date, 20 September 2021. And then he continues, they were bringing their people every night. We have been up to 17 people in that room. He did not recognize anybody from the people who were brought to that room. The witness stated this on Monday, 20 September, page 419 of the transcript. Upon his release, the witness also testified about the amount of people that were there at the time of the release. And I quote him, "It was us, so the persons that were there, I was the person before the last, almost 17 people, I think. So we left the place and I left just one person behind. So at the end, there were only 3 of us. So I stopped, then I left 2 other persons when I left. When I left the building, I left 2 people behind myself." Well, Your Honor, even though the witness is not completely clear about how many people he was with, the answer indicates that at least there were 17 people at the time of his release. The 20th of September, page 484. The conclusion is that this is the only witness that speaks about at some point 17 people. It is not possible, if we look objectively at the place where they were allegedly held, to fit so many people in that place. And I speak about the basement of what the defense calls the ODA. Witness 1679, Your Honor, said the following: when he was taken there, he found there the alleged murder victim, 3594, 3593, though he indicated that the surname of this person was different than the actual name of 3593, and he mentioned another person, Your Honor, that has never been identified. May we go one brief moment in private session?
Madam Court Officer, could you bring us into private session, please?
Your Honor, we're back in public session.
Thank you, Madam Court Officer. Defense Counsel, you have the floor.
Thank you very much, Your Honor. 3594 then. With how many people approximately were you were you at the maximum in the stable? The answer of this to this question is, are you asking how many people could stay there in the stable? Is that correct? Is that the question? No, sorry. My question is, with how many people in total were you included in that stable? The answer that the witness said is, so once we were 5 persons, and then it was 6 of us there. The witness stated that on the 12th of October 2021, page 1186 of the transcript. Also, W4669 discussed the amount of people. And he said, when I got inside that room, I saw 2 other people. The witness stated this on the 10th of November, page 1415 of the transcript. And he says about those people, he did not know the people that were inside. He never got the names of them. After the war, he got a telephone number of one of them. This person had 2 sons that had joined the KLA. He states that on 10th of November, page 1417. Then about the other 2 people in the barn, he says he remembered that the other 2 people were brought there 3 or 4 days before the witness. That is the transcript, 10 November, page 1424, line 19 of the transcript. At a certain moment, the alleged victim of the murder was brought there where the witness was staying. The witness knew this person. He knew this person. Your Honor, I would like to go into private session for a brief moment.
Madam Court Officer, could you bring us into private session, please?
Your Honor, we're in open session.
Thank you, Madam Court Officer. Defense Counsel, you have the floor.
Thank you very much. Our general conclusion regarding the witnesses that we have just discussed, 1679, 3593, 3594, and 4669. The witness mentions people that other people do not mention. In particular, W1679 mentions 3593, 3594, the alleged victim of the murder, 04669, and a person called Burmak. Then if we take a look at 3593, he mentioned the alleged victim of the murder, 3594, and Burmak. If we take a look at 3594, he mentions 3593, Burmak, the alleged victim of the murder, and mentioned 3 people by name. And lastly, 4669 mentions only the alleged victim of the murder in this case, and that is 1 person by name. So, they were in the same time, in the same place. However, nobody mentions the same people by name or by indication. We do not believe, Your Honor, that based on this, there is probative value in the accounts of all these witnesses. We give only one example, but we can give more. W1679 puts W4669 with him in the barn, while at the same time W4669 never mentions W1679. And we could go on like this. Your Honor, I would like to conclude for this moment this part, and I would like to move to the topic of arbitrary detention. Arbitrary detention of 7 people. According to the pre-trial brief of the SPO, paragraphs 52 and 59 of filing F00088 Annex 01, page 19 to 21, document F00088 Annex 01, there were 7 people detained. The defense will discuss the ones that have testified. The other people who have not testified have been either missing, dead, or the person has not been able to be tracked down. That leaves us with 4 detained people. The detention of W1679 according to the SPO. According to the SPO's pre-trial brief, paragraph 53, W1679 was arrested on the 1st of April by armed members of the KLA BIA unit. In the final trial brief of the SPO, paragraph 33, It reads that W1679 was arrested on the 5th day of his training. At least 4 armed soldiers dressed in black and took him with them. Dressed in black uniforms and took him with them. Now, for many reasons, we do not believe that the SBO claims, we do not believe what the SBO claims on the date, and even what the witness said about the training that he received is possible. Important is the following, Your Honor. Important is to note that W1679 claimed he was trained by Adem Shehu. He testified that on the 4th of October 2021, on page 864 of the transcript. We know for a fact, Your Honor, that Adem Shehu, commander of Brigade 153, according to his own statement, did not arrive earlier than the 28th of March 1999 at the Brigade 153. The SBO interviewed Adem Shehu on the 27th of January 2021, ERN 090258 TRET, Part 2, page 6, line 9 to 16, and page 10, line 19 and 20. And the interview was also, the defense also interviewed Shehu. Adem Shehu never said that he had trained any recruits in Slash. He had trained people in Tirana. That's 27th of January, that is ERN 090258 TRET Part 2, page 5, line 13 to 15. According to Musli Halimi, during the time that he was there, a commander of the training center, until the 7th or 10th of April, Adem Shehu was not an instructor of the recruits. He stated this in his testimony on the 20th of April 2022. Second point, if W1679 was arrested, so he said, and according to the SBO, on the 5th day of his training, and given the fact that Adem Shehu arrived on March the 28th, W1679 must have been taken or arrested on the 2nd of April at least. It is unlikely that Adem Shehu would have started to train people at the Slash training center on the day of his arrival. Let us not forget, Your Honor, that Adem Shehu walked from Albania to Kosovo and he arrived on foot in Slash. He stated this on Wednesday, 27th of January, and that is ERN 090258 TRET Part 2, page 6, line 9 to 16, and page 10, line 19 to 20. Now, Mr. Shehu is a fit man, but I do exclude that after 18 days of walking, he would start training recruits on the same day of his arrival in Slash. Indeed, the bare minimum theoretical case that W1679 would have been trained by Shehu would have been on the 28th of March, and calculating from that day, the minimum is the 1st of April. This is just to say that even if 1679 indeed got his training from Shehu on the day that he was arrested, that his story does not simply add up. That is due to the following point. Point 3. Another conflict with this assertion is the following. In this context, it is interesting that W1679's testimony in court, he stated that when he arrived in the place of his detention, he found there the alleged victim of the murder, W03594, then W03593, however, he gives a different surname, and a person called and I would like to go into private session.
Madam Court Officer, could you bring us into private session, please?
Your Honours, we're in open session.
Thank you, Madam Court Officer.
Point four.
Defense Counsel, you have the floor.
Thank you. Point 4. According to W3594, he, that is 3594, was arrested on the 4th of April 1999. W1679 stated when he entered the barn for the first time, he saw 4 people, including 3594, being one of these people. So it turns out that 1679 was then arrested after 3594 had already arrived in detention. Otherwise, 1679 could have never seen him upon his arrival in the barn. And 3594 is sure about the date of his arrest, which was after a date that he referred to. Your Honor, may we go in private session?
Madam Court Officer, could you bring us into private session, please?
Your Honours, we're in public session.
Thank you, Madam Court Officer. Defense Counsel, you have the floor.
Now, the defense finds it important to note that the only person who was able to make a reference to a particular event of a date was 3594. Neither any of the other witnesses of the SPO regarding their detention was anybody able to give a point of reference to which they were referred to. And we should say that this is in stark contrast with the witnesses of the defense. Still, if W1679 maintains that he was kept for 18 days, then he would have been released on the 23rd of April, that is after the Serbian offensive. 5. Now, if it was on the 1st of April that 1679 was arrested, then this story still doesn't make any sense. 1679 was arrested in the late morning, according to himself, around 11 a.m. However, the alleged victim of the murder was arrested by W4600 did not arrive until late in the afternoon. So even if in that case it is not possible that 1679 found the victim of the alleged murder in that place of detention. Point 6.
Your Honor, we're in open session.
Thank you, Madam Court Officer. Defense Counsel, you have the floor.
Point 7. Now we have mentioned that the trainer of the new recruits said about the start and the finish of the recruits. Musli Halimi said that there was a fixed schedule where at the beginning of a month a training would start, or about the 15th of a month. Each generation would start on either of these moments in time. There was no such thing that people could just come and stop at the school and they would join the KLA as a soldier. There was a fixed procedure for that. The new recruits came from the list that were furnished by the brigade command. Point 8. In addition, when speaking about the release, W3593 told about his release. He said that only 3594 and the person that I mentioned earlier, Your Honor, in the private session, went to the family of the alleged murder victim. He, 3593, never mentioned 1679 going there with them. Point 9. The corroborating evidence of the list of prisoners does not add up as well. The SPO refers to this list of prisoners, paragraph 171 up to 174 of the SPO's final trial brief. The list of prisoners that the SPO used as corroboration for this assertion that 1679 was abducted in early April does not fit. The list of prisoners on which a person with the name of 1679 is listed says that he was imprisoned on the 3rd of April. If the calculation of 1679 would be right in saying that he had been held for 18 days and 17 nights, that makes that he was released the 20th of April. That is about the time that Dr. Teota Hadri and Ibadeta Chiu Kanoli would already be there treating and operating patients in the building where W1679 claims he was kept. This is the statement of 1679, the 4th of October. Then the detention of 3593, according to the SPO. 3593, according to SPO in the pre-trial brief, paragraph 54, was arrested about the 1st of April. In the final trial brief, paragraph 45, he was arrested at the beginning of April. An overall observation about this witness is that we have never been able to connect his story to any kind of point of reference. He did not connect it to the NATO bombings, not to anything that took place in or around his house. He could not remember, and therefore he could simply have no point of reference. He just says it was the 4th. We do not know what this date is referred to. It is just a blank number. He does not even give a month, simply because he doesn't know. Statement of him on the 20th of September 394 is the page number of that date. The fact that a witness just names a number and is unable to connect this number to any moment, a birthday, a bombing, or a personal event, or even an event that might have taken place in his village, is a general indication that whatever the witness says about it cannot be relied upon. Calling just a date without connecting it to any point of reference has no probative value in a criminal case. But it might explain why the SPO deviated from its initial point of the view that he was arrested on the 1st of April, as stated in the pre-trial brief, to the beginning of April in the final trial brief. The corroborating evidence of the list of prisoners does not add to the assertion of the SPO that it was on the 1st of April. The SPO refers to this list of prisoners in paragraph 171 and 174 of the SPO final trial brief. The list of prisoners, Your Honor, the list of prisoners that the SPO used as corroborating evidence for his assertion that 3593 was abducted in early April, that list, if it is the same person that would be envisaged, indicates, however, that the name that is listed was on the 2nd of April. Further, the witness was extremely occupied that the accused was the one that had beaten him. He said he knew that for a fact. Statement of him on 20 September, page 413. I quote, "The person that was there was the accused." How do you know that? This was the question of the prosecutor. But at the moment that he was questioned, what the basis was saying that, he says, "I know that for a fact." The witness was unable to answer this. He just kept on saying that. The defense made an issue out of it, especially when the person just mentioned somebody here, while he had never seen that person or even knew him before. Statement on the 22nd of September, page 595. The defense is of the opinion that simply saying, I know that for a fact, has no probative value whatsoever. Another example of this witness is to assess his credibility on general topics and on specific topics as well. According to him, he was arrested and put into a barn. That was on the 4th. That's it, nothing more. Well, if the document called List of Prisoners is correct, then it is not the 4th. According to that document, it's the 2nd. So maybe the witness is right. Then the conclusion is that the List of Prisoners document is not correct and has no probative value and does not corroborate anything in that perspective. He described in total 3 places where he was kept for some time, but upon the first moment that he was put into a place, he gave an indication regarding the time of the day. Second, the witness stated that it was on the 4th that he was detained. And if we take the word of the witness as an unforgettable, life-changing experience, then the following point is, for how long was he kept there? He stated that he slept in water for 18 days. 20 September, page 418. That would mean that the witness was released on the 22nd of April, even though he said that the offenses had started on the 18th. The witness stated that on the 20th of September, page 419. This is the same. He just gives a date, but he cannot connect this date, or better to say, to any other event. If his date of release would have been the 18th, and assuming that he was detained on the 4th, then it means the witness was again not accurate. He would have stayed there only 14 days in the place where he was kept. Then the detention of 3594, according to the SPO. 3594, Your Honor, according to the pre-trial brief, paragraph 55, was arrested on the 5th of April. And in the final trial brief, paragraph 61, he was not arrested, but he went out of free will with 2 people that came to look for him. And this was on or about the 4th of April. He was detained the same day. The witness is, for a couple of reasons, a witness whose testimony is reliable. This is due to the following factors. He was not masked at any point, so he could give a fact. He could in fact give descriptions. He was not put a bag over his head. He was taken out of the barn to have what he called a conversation. He could recognize people and describe people who interrogated him and those standing by. He could describe places, the meaning of the rooms where he was interrogated, on the place where he was kept. Lastly, he was able to leave the barn to be brought to the toilet, and he could give a description what he actually saw and what the location looked like. Your Honor, even though the SPO alleged that he was arrested on the 5th of April, the witness stated it was the 4th. It is for that reason that probably the SPO changed its initial view of that day of the arrest of this person. The SPO witness stated that the accused, Salih Mustafa, was not present during the time of his interrogation or conversation. On the question of the defense whether anyone who was present at the time of the conversation, he spoke about Salih Mustafa, the witness replied, "Mr. Lawyer, I know Salih personally. Had anyone mentioned his name, I would say yes. And he knew Salih Mustafa from before. He knew him in person. He never heard or saw Salih Mustafa as he was in Slash. I quote the witness, "Had I seen him there, I would not have defended him, even if he were my brother. But I did not see him there, and I would have seen him upstairs when I went upstairs, but I did not see him there." Page 1210, 1210, on 13 October. So this witness is very clear and could at least give information simply because there was no sack over his head. We do believe, at least, this witness was able to determine things that testified about it. W4669, then, Your Honor. According to the SPO in the pre-trial brief, paragraph 56, he was arrested in April 1999. According to the final trial brief, he was stopped in March or April, but the witness was never conclusive about this. 4669 actually stated that he reported around the sometime in February 1999, according to his statement. That is the transcript of 10 November 2021, page 1391. He stated actually that and I quote, "I was 4 or 5 days later, or a week, when we went there, to Slash to report there. After he finished the training in Slash, he left back home. We estimate that this witness, if he had trained in Slash, must have been in the beginning of March. We know that the training ended the 15th of March, as Musli Halimi, the trainer in the school, stated. He went on to say he went back 1, 2, 3, or even 4 more times, as he had to present himself in Slash. It must have been on the last time, the 4th time, that he was stopped and eventually was taken by 04600 to Slash. And it has not become clear, Your Honor, when he was eventually...
Your Honor, could you ask the counsel to slow down, please?
Or
Counsel,
April. I go too fast.
You have heard what I was told,
Yes.
and could you slow down? And I take the opportunity to have a look at the clock, and we are
Yes.
approaching 4 o'clock. So please, try to be ready for 4, and then we take half an hour break, and
Yes.
then we continue for another hour.
Yes.
Or less.
The next topic is really a different topic, so I'd like to finish this topic and then take that break.
That's good. I could agree with that, but I would like to finish at 4 because
Okay.
to have a break at 4.
Okay. Okay.
because we have been, the interpreters have been working the whole day.
Yes.
So I really want to stick to our agreements on
Understood, Your Honor.
the
Understood.
the moments of break.
Okay. Yes. On page 1452, witness 4669 stated, but later on I returned there again, but that was a different sort of return. I was armed then, and I was with many others. We would distribute supplies for the army. This is when I went there for the last time after the NATO bombing had started. 4669 stated that he had been beaten by some people. The people that beat him were younger than himself.
We will have a break till 4:30. The hearing is adjourned.
Okay.
All rise. All rise.
Please be seated. Welcome back. We will proceed with the last hour of today's hearing. Defense Counsel, you have the floor.
Thank you very much, Your Honor.
Yes, and I gave a glimpse, but I have to say it for the record, we are in the same composition as before the break.
Honourable members of the court, we would like to make submissions about the law regarding arbitrary detention. In paragraph 23 until 30 of the decision of the confirmation of the indictment, the pre-trial judge, and that's filing F0008, conf. Red, notes that the crime of arbitrary detention is not listed in the law of the specialist chambers. Article 6 of the law provides that the specialist chambers shall have jurisdictions over the crimes set out in Article 12 to 15 of the law. The war crimes of cruel treatment, torture, murder, as pleaded by the specialist prosecutor, are listed in 14(1)(c), 14 paragraph 1(c)(1) of the law, and therefore will fall within the subject matter jurisdiction of the specialist chambers. The pre-trial judge states in paragraph 23 of the decision of the confirmation of the indictment that the SPO submitted in its further revised indictment that Mr. Mustafa is also criminally responsible for the war crime of arbitrary detention, count 1, in violation of Article 14(1)(c) of the law. The pre-trial judge notes that while this provision does not explicitly list arbitrary detention as a war crime in non-international armed conflict, it does not limit the crimes falling under the specialist chambers' jurisdictions to those expressly enumerated therein. I continue, nonetheless, in order to exercise jurisdiction over a war crime that is not listed in Article 14(1)(c)(1) until 4 of the law, such crime must 1. Constitute a serious violation of Common Article 3, and 2. Be prohibited by customary international law at the time of its commission in conformity with Article 3, 2d, and Article 12 of the law. The pre-trial judge states in paragraph 24 that Common Article 3 provides that persons taking no active part in hostilities, including those placed hors de combat by sickness, wounds, detention, or any other cause, shall in all circumstances be treated humanely. This protection, also stipulated in Article 14(1) of the Protocol additional to the Geneva Convention of 12 August 1949, and relating to the protection of victims of non-international armed conflict, Protocol 2 of 8 June 1977, must be enforced by all parties to the armed conflict and must be afforded to all detained persons, irrespective of the reason for their deprivation of liberty. The trial judge goes on and notes that the requirement of humane treatment constitutes a fundamental obligation of international humanitarian law and reflects customary international law. It is broader than the prohibitions expressly listed in Common Article 3, which serves as example of conduct that is indisputably in violation of the provision. The pre-trial judge states in paragraph 25 that deprivation of liberty without a legal basis or in violation of basic safeguards is not compatible with and violates the requirements of humane treatments of all persons placed hors de combat, including by detention as enshrined in Common Article 3. The pretrial judge goes on and notes that in paragraph 26 that customary international law prohibits arbitrary detention, prohibits arbitrary deprivation of liberty. Extensive state practice in the form of, inter alia, military manuals, criminal legislation, documents of international organizations and conferences, and international judicial and quasi-judicial bodies establishes the applicability of this prohibition in both international and non-international armed conflict. This is also being confirmed by the ICRC in Rule 99 of its 2005 customary international humanitarian law study. In light of the foregoing, the pre-trial judge finds that arbitrary detention constitutes a serious violation of Common Article 3 and was prohibited by customary international law at the time of commission of the crimes alleged in the further revised indictment. The status of the law at the national and international level was sufficiently clear and foreseeable to anticipate that depriving someone of his liberty in an arbitrary manner might give rise to individual criminal responsibility. Accordingly, the pretrial judge concludes in paragraph 28 that the specialist chambers may exercise jurisdiction over this war crime under Article 14(1)(c in combination with Article 12 of the law. The pretrial judge, Your Honor, defined the arbitrary detention as follows in the confirmation of the indictment in paragraph 49. The crime of arbitrary detention as a war crime within the meaning of Article 14(1)(c of the law is committed through an act or omission resulting in depriving a person not taking active part in hostilities of his or her liberty without a legal basis or without complying with basic procedural safeguards. On arbitrary detention, the position of the defense is the following. The crime of arbitrary detention is not listed in any of the articles in the law of the specialist chambers. The Common Article 3 of the Geneva Conventions is about the treatment of protected persons. In the Geneva Convention 1, 2, 3, and 4, the wording stipulates, shall be treated humanely. The wording, be treated, is not by chance. The treatment that is forbidden is listed in a number of acts that are listed in Article 14 of the law of the specialist chambers. It is an error of interpretation of the law when the pretrial judge put arbitrary detention in the box of Common Article 3 of the Geneva Conventions. The law of the specialist chambers defines as a war crime in Article 14 of the law, and I quote, for the purpose of this law, under customary international law, war crimes means, and then the long list stipulates the acts. Fact is, Your Honor, that none of the acts in Article 14 under C lists the act of arbitrary detention. The act of unlawful confinement is listed only under Article 14a(7). Arbitrary detention is not listed under Article 14c at all. Article 14c speaks about taking hostages. However, the detention of the people in itself does not amount to hostages in the sense of the wording that is meant in the common interpretation of that word in international law. Detention does not in itself constitute violence to life. Neither does it constitute murder, mutilations, cruel treatment, or torture. Detention does not constitute in itself an outrage upon personal dignity, in particular, humiliating and degrading treatment. This wording is being used in Article 14c under 2 of the law of the specialist chambers. Again, here we clearly see again treatment of people. And this is in line with the acts that are listed in Common Article 3 of the 4 Geneva Conventions. The protected persons under the 4th Geneva Conventions. That is the following topic. The 4 Geneva Conventions protect several types of people. In each of the conventions, these people are defined. The wounded and sick of Convention 1 are defined, as well as the protected persons in 2 and 3. The 4th Geneva Convention is about the civilian population. Article 4 of the, Article 14, of the 4th Geneva Convention reads, persons protected by the conventions are those who, at a given moment and in any manner whatsoever, find themselves, in case of an armed conflict or occupation, in the hands of a party to the conflict or occupying power of which they are not nationals. The commentary of the 4th Geneva Convention reads as follows, and I quote, the very title of the convention shows in a general way whom is meant to cover, but it is advisable to be able to determine exactly what classes of persons are protected. This is the purpose of this article. This article is, in a sense, a key to the convention, for it defines the people to whom it refers. End of quote. The commentary to this Article 14 of the convention continues that then to define the people that are protected by the Article 3 of the Common Article 3 of the convention. And it reads, and I quote, as for the territory of the belligerent states, protection is accorded under Article 14 to all persons of foreign nationality and to persons without nationality. And then the commentary reads the following as with the definitions of this article. The definition has been put in a negative form as it is intended to cover anyone who is not a national to the party of the conflict or the occupying power in whose hands he is. The convention remains, therefore, faithful to a recognized principle of international law. It does not interfere in the state's relation with its own nationals. End of quote. The defense, therefore, disagrees with the observation of the pre-trial judge in paragraph 25 of the confirmed indictment that, and I quote, deprivation of liberty without a legal basis or in violation of basic safeguards is not compatible with and violates the requirement of humane treatment of all persons placed hors de combat, including by detention as enshrined in Article 3. Once again, Common Article 3 does not in any manner enshrine, and certainly not in the manner as formulated under Article 14(1) of the indictment, the detention of people. It is about the treatment of those who are in the hands of the belligerent parties to the conflict. For this reason, the defense concludes that the basis for the indictment, namely Article 14(1)(c), does not list and does not even define the crime of arbitrary detention. Moreover, as the Convention clearly envisages not to interfere with the principle of international law, not to interfere in the state's relations to its own national, the defense is of the opinion that the act of arbitrary detention cannot be qualified under the chapeau of Common Article 3 of the Geneva Convention as envisaged by the SPO in the indictment. In the case of the people that were allegedly detained in this case, they were nationals of the Federal Republic of Yugoslavia or the autonomous socialist province of Kosovo. Therefore, the law of the land would apply for this kind of act. In any event, it is not the law of the specialist chambers that can be applied for these people. Article 14(c) is not applicable or simply cannot be applied. It is not enshrined in Common Article 3. Then, an observation regarding the armed conflict. Kosovo declared its independence in 2008. Kosovo was in 1999, during the period of the indictment, part of the Socialist Federal Republic of Yugoslavia. Until 1990, Kosovo was known as the Socialist Autonomous Province of Kosovo. After 1919, it was a simple province of the Socialist Federal Republic of Yugoslavia, as the autonomous status was dissolved by the Serbian parliament. From June 1999, it was under United Nations interim administration. Legally speaking, even with a different administration, this did not change its status. Eventually, Kosovo was able to become an independent, sovereign state, at the cost of many lives and for which struggle many people gave their life. The geographical and status of Kosovo is important to note in the context of the characterization of this conflict. Initially, the armed conflict in Kosovo could be characterized as an armed conflict not of an international character. However, on the 23rd of March 1999, Mr. Javier Solana, the Secretary General of the NATO, stated in a press conference, and I quote, "I have just directed SACEUR, General Clark, to initiate operations in the Federal Republic of Yugoslavia. In Belgrade, the state of emergency was declared at the same time. The NATO airstrikes under the name Operation Allied Force was set out in 5 phases and ended in June 1999. NATO is of course consisting of a group of countries, And it was all these countries that agreed for the Operation Allied Action. As such, all NATO countries became part of the conflict in the sense that they became one of the belligerent parties to the conflict. It is irrelevant if Yugoslavia targeted the individual countries, but they certainly fought against the forces that were applied by the NATO countries. And in a number of cases, they were effective in targeting NATO forces. Whatever the motives of the NATO were, is not relevant to the case of Salih Mustafa. What is relevant is that from March 24 onward, another belligerent party, namely the joint NATO countries, joined in the conflict. Whether NATO countries were bombed by Serbia is irrelevant. Serbia nevertheless declared war against NATO countries. This is laid down in the OSCE document of March 25, 1999, ERN SBOE 000-6124-43. The defense submits, Your Honor, that from 24th March onward, at least the characterization of the armed conflict can be and must be qualified as an armed conflict of an international character. This is in line with the jurisprudence of the ICTY, in particular paragraph 1580 and 1581 of the Dordovic case of the ICTY, that is case I-0587-I-T. As for NATO, who carried out the attacks, the Geneva Conventions would also apply. The fact that NATO became part to the armed conflict can be concluded as the criteria for being a party apply for the NATO. The two determinative elements of an armed conflict are intensity of the armed conflict, and the level of organization of the parties. As for these two determinative elements, the defense submits that NATO certainly fulfilled these elements. It can be concluded from the following acts: the series of the NATO attacks and an increase in armed clashes, in particular also with NATO forces, the spread of clashes over the territory over a period of time, as NATO bombed both in Kosovo and in Serbia and other areas of the Federal Republic of Yugoslavia. In addition, there was a number of increase in the number of government forces, and there was mobilization and the distribution of weapons among both parties to the conflict. Lastly, the conflict has attracted the attention of the United Nations Security Council. With respect to the organization of the parties to the conflict, the defense believes that that for NATO, it must be taken into account that factors such as the existence of a headquarters, the designated zones of operation, and the ability to procure, transport, and distribute arms. From the 24th of March until June 1999, there was an enormous intensity from the side of NATO as regard to the targets they had in mind in both Kosovo and the Federal Republic of Yugoslavia. The intensity was such that on or about the 9th of June, the hostilities ceased. This all means that when looking at the period of the indictment, which is April 1999, this falls within the period of time of the NATO airstrikes. These airstrikes originated from outside Kosovo and the Federal Republic of Yugoslavia. The NATO had no UN mandate, and the airstrikes were not part of any kind of peacekeeping operation. The NATO's airstrikes have been always heavily debated as there was no legal mandate for it. As the characterization of the conflict makes a difference, the defense submits that Article 14(1)(c) of the law would not apply, as it is only tailored to an armed conflict not of an international character. I move on to cruel treatment. The defense wishes now to discuss the issue of cruel treatment, count 2, as well as the alleged torture of the 7 individuals, that is count 3. The crime of cruel treatment is found in Article 14(1)(c)(i) of the law of the specialist chambers. The war crime of cruel treatment is not in any manner defined under the law of the specialist chambers. It is only mentioned next to mutilation and torture. Next topic is the armed conflict. In order not to become repetitive, Your Honor, the defense reiterates its position on the characterization of the armed conflict, as well as the things we have just said about the protected persons under Common Article 3 of the Geneva Conventions. The protected persons under Common Article 3. Also, the defense position on whether the individuals that were held would fall under the protected persons in this regard is the same, as I just stated earlier. To that effect, we pointed out that the individuals are not falling under the protection of the persons that are envisaged under Article 14 of the Geneva Conventions. The general position of the defense regarding this crime, that is count 2. It is the position of the defense that Mr. Mustafa did not commit this crime. It is as simple as that. He was not even aware of the fact that these people were in fact detained, or for whatever reason they might have been detained. He does not know where they were detained. He has not ordered nor instigated these crimes. Mr. Mustafa did not commit any cruel treatment through the modes of liability as indicated by the SPO. There is no evidence that proves any omission by him that cruel treatment would have been committed against any of the individual, so no commission by omission. He does not even know 3 of the 4 individuals that we will discuss. The 4th individual, 03594, is someone whom he knew. However, the witness, 3594, stated that he has never seen Salih Mustafa on the scene. And had 3594 seen Salih Mustafa, he would have said so. That was very clear in his testimony. In his own words, even if he were my brother, I would not have defended him. The elements of the crime. As for cruel treatment as a war crime, it is necessary that the perpetrator inflicted severe physical or mental pain or suffering upon 1 or more persons. In addition, the treatment must take place in the context of and was associated with an armed conflict not of an international character. As regard to mens rea, the perpetrator must have acted with direct intent to commit cruel treatment or with indirect intent, that is, in the knowledge that cruel treatment was a probable consequence of his act or omissions. The conditions in Salih. Salih is a remote hamlet on a hilltop, as we have seen. No sewage, no regular water supply, but a well, no tap water. Electricity was not available based on the witnesses that were present at the compound. No street illumination. These were witnesses of the defense who stated that. No paved road, no flushing system of the toilets, No toilets at all in the house, just a field toilet that were there. There were no showers available, no possibility to laundry or a washing machine for the clothes. When describing the houses, Fatmir Stopi stated, Bia location was like any other location in the area. He described that the houses in the compound looked like any other house in the area of Golak, according to Mr. Sopi. I quote him. It was a normal village house with a yard and a building for living there, the same as our houses, because the KLA did not have barracks. Sopi stated this, his perspective on page 2048 on the 18th of January 2022. The houses at the location were built by the people themselves. It is not a developed urban area. No construction company that developed the houses in as they develop in urban areas. These houses are mainly the work of men who build this by themselves with their family. In other words, there were no facilities available for hygiene as we know it in 2022, or not even how people in the city of Pristina would live at the time of the events. There is no distinction for the people who were seeking refuge or anybody who would live there. The conditions are as they are in such location. The SPO's position on the cruel treatment. The SPO discusses the cruel treatment in its final trial brief in paragraph 295 until paragraph 302. The cruel treatment in the eyes of the SPO consists of two factors in paragraph 295 of its final trial brief. By establishing and maintaining inhumane conditions and by inflicting beatings and other forms of maltreatment, including serious mental and physical harm. The accused and certain other KLA members subjected at least 7 people to the cruel treatment as specified above. About establishing of the inhumane conditions. As for the establishing and maintaining inhumane conditions, the defense position is that these conditions were not established by either the accused or by any other of the KLA soldiers that are envisaged by the SPO. The defense notes that there was a huge amount of people who were internally displaced. These people were also at the Slash location, where the allegation is that people were held. But these people would even sleep outside, and there was no toilet or facility where they could wash themselves or their clothes. All these people just coped with the situation as it was. A large group just camped outside. As far as the evidence is concerned, nothing indicates that the conditions as they were organized or arranged were set up by the KLA, the BIA, or anybody in particular. We have no testimony about setting up anything in particular in that regard. The 4 individuals that testified about their treatment, of the 7 individuals that were allegedly detained at the Slash detention compound, 3 of them at some point have spoken about their cruel treatment. There is no information about Burmak, who to date is a still missing person. There is no information about the alleged murder victim. Place where the other detainees the other detained people were staying. That leaves us with 4 individuals who testified in court. 3594 stated the following regarding his treatment. So you stated, that was the question, that you had been beaten once, but the others, they had been beaten at least once more. Do you recall that? And he answered, no, I do not remember. So probably I have been misunderstood. So they have not been once more or one time less. So that was hitting the hands. It was not, not something major. It was like hitting a pupil while in the elementary school. So I was not beaten in my limbs, in my hands, or other parts of my body. Like I said, that person was very young, and I treated that person like my kids. I had no anger whatsoever. I just was sorry about him. I was not sorry about myself. And like I said, that was something that only happened once, and that happened to everyone else. There was no difference towards myself or others. There was just one person. So about the stick, I do not know whether it was a rubber stick or a wooden stick, but it was very light and I didn't feel any suffering or pain at all, although my hand is damaged. That is transcript page 1070 and 12 of October. The witness withdrew as a victim during the court session. The defense position on this individual, 03594, is that he has not been cruelly treated. The conditions under which he was held do in itself not amount to cruel treatment. It does not in any manner inflict severe pain or suffering on the person. The apparent act, hitting someone on the fingers, does not amount to severe pain or suffering. It is anything at all. It would be a local offense that is to be treated by a local court. W4669 stated the following regarding his treatment. He never stated that he was beaten by a person called Salih. Salih was never mentioned by the witness, so there is no indication that the accused, Salih Mustafa, actually committed any beating to him. In fact, the witness did not at all name any person with a name or a nickname who maltreated him. He just knows the age of the people who maltreated him. And according to the witness, these 2 persons who beat him up were about 17 or 18 years of age. That is the transcript of 10 November, page 1446. Even though there were 2 older persons standing by, they were not involved in the beating, and the witness did not know or mention the names. As far as the beatings is concerned, he said the following. They told me to bend down. Do you want me to show how exactly they told me to behave? So I was standing and they asked me to bend. And this is how I stood. Like I said, I wasn't wearing any clothes in the upper part of my body, and I was hit in the shoulder. So from this part up here until here. So I was hit by a rubber stick that was kind of a stick that was a baton that was used by militia, by the Serbian military forces. It was not a metal rod, but that's, like I said, a police rubber stick. Do you remember how? It was a baton. 10 November, page 1444. Let me get back to my question, was the question. Do you remember how many times you were hit with that, as you say, rubber baton? Answer, only that night. My question, it continued, my question did not relate on how many times you were beaten while in Salih. My question relates to how many times you were hit in your back with the baton, if you remember. About 12 times, even more than that, the witness stated. 10 November, 1445. The motives, Your Honor, for the beating or cruel treatment. 3594. We have no objective information about the motive why people were beaten. 3594 stated that upon a leading question of the SPO, thank you, Mr. Witness. In a statement of a witness is just speculation. The conclusion is that there cannot be established a reason for his arrest, but why he was slapped on his fingers and why he was slapped on his fingers cannot be established. And that happened while he was detained downstairs. So this beating, I place that in brackets, is not related to cruel treatment as such. The defense already said that the witness was not treated.
Defense counsel, please
Slow down.
stop because we lost the connection with your client.
Okay.
Mr. Mustafa, can you hear us?
Yes, I can hear and I can see you. There was an interruption earlier, however.
To recap some of the things he said. Defense counsel, you have the floor.
Thank you very much. We can simply conclude that whatever the motive was to either detain or beat the witness, it is just based on a thought by the witness. There is no confirmation from any objective source what would be the motive to do this to him. But to fill in the blanks in a statement of a witness is just speculation. The conclusion is that there cannot be established a reason for his arrest, but why he was slapped on his fingers cannot be established as well. And that happened while he was detained downstairs. So this beating, and I place that in brackets, is not related to the cruel treatment as such. The defense already said that this witness was not treated cruelly, let alone that it could have been done by Salih Mustafa. Witness 4669. We have no objective information about the motive of why people were beaten. 4669 stated that, I do not know about other people. Probably there was older people. However, later on, once I analyzed things, I think that they did not plan for me to be beaten up. I think this was related to our political bias, to our political convictions, to military convictions as well. That is something that has happened to other people as well. I think that is the reason to do that. It is not that we are spies, because that had nothing to do with us being spies. We can simply conclude, Your Honor, that whatever the motives was to either detain or beat this witness, it is just based on later analysis by the witness. There is no confirmation from any objective source. What would be the motive to do this to him? To fill in the blanks in a statement of a witness is speculation. The conclusion is that there cannot be established a reason for his arrest, detention, or the beatings that he suffered. So the court cannot make a finding on this. Then we have two witnesses left who allegedly were cruelly treated. 3593, the frequency of the beatings. 3593 was, according to himself, beaten 2 times. Once when he arrived and once other time. The first beating occurred upon his arrival at the place where he was kept. The amount of perpetrators, he was asked, answer was, it was 3 or 4 people. So like I said, the sack was placed over my head and they took me outside, like I said, and they started to beat me up. I didn't exactly know who those people were. 20 September, page 407. Another answer, well, I don't know who hit me there. I can't know. And so there were 4, 5 persons. They beat me up in all ways possible, however they wished. And, like I said, I fainted for a couple of times. And I don't know anything else. 20 September, page 415. About the possibility of observe perpetrators. Well, I don't know how they beat me. I can tell you that I fainted a couple of times. 2, 3 times I fainted. I was hit with wood. I was kicked. I was hit in different ways. I was hit, I don't know what with. So my finger was broken. My teeth were broken there. So I'm injured in the head. So I had a surgery in the head. So that's all I can say. 20 September, page 409. About his injuries. As I told you, when I was taken the first day, he punched me on the face. Some of my teeth were broken, but not all of them. But when I was beaten, then they were hitting me, kicking me, and with every sort of instruments. And that's when my teeth were broken, and I can't remember everything because I fainted on and off. Words spoken by the perpetrators. They didn't say anything. They were just calling me names. So they were speaking in all different sort of things. So they were beating at me, they were swearing at me. So like I said, they once hit me in the head. So they kicked me, they hit me with a piece of stick. And I mean, that's all I can say. I don't really exactly know. Page 409, 20 September. I'm speaking about the first occasion. I wasn't able to hear because I was being hit simultaneously by 5, 6 persons. I wasn't even aware what was happening to me. 20 September, 429. And about the duration, Your Honor, he said, I have no idea how long they have been beating me up for because I didn't have a watch. There was no electricity. I don't know. So probably I was there 2, 3, 4 hours. I can't even tell. I don't know. But The prosecutor asked, "My question does not deal with the time of your beating. My question deals with the moment, the event. How did that beating end? Because at some point it ended, I understand. And how did it end? This is my question." And the answer was, "It's obviously. So they beat me up for a long period. So I fainted a couple of times. They'd throw water upon me, and they did drag me and send me to the other room. And I didn't know anything back then. In that point in time, so I just lied down in the water, in the barn, probably up until the next day. I don't know what time it was back then. But I was standing up until the next day." About the use of weapons, Your Honor, this person says, "During the beatings that you just described, did any of the perpetrators use a weapon at any point?" Answer was yes. "Could you tell us more about the use of this weapon?" "When I was lying, one of them got a revolver and he put that in this place. So he put the revolver over here and I heard the sound. So I had the impression like I was being killed. So for one moment, so he made that noise with a revolver, but the fact was that it didn't shoot. So then, and then that person said, "You know what? Let him be, because this man is lucky." About the motives for the cruel treatment, the witness said, the question was asked, were they making any accusations in relation to you? Answer, yes. No, they didn't say anything to me, but they were just accusing me of being a collaborator with the Serbs. And about the second beating, the question was asked, you said that you were asked a question that related to the fact that you might know some thieves. Do you remember any other question asked by that person to you? Answer, he didn't say anything else. He just asked me on whether I knew some thieves. So either tell us, otherwise we would kill you. If you tell us, we will send you home. That's what he told me. 20 September, page 438. Question, were they making any accusation in relation to you? Yes, no. They didn't say anything to me, but they were just accusing me of being and collaborating with the Serbs. Then we come to witness 1679, the tools used at the beating. Well, they would kick us, beat us with wooden sticks, iron rods. They would burn us with candle. They would keep the candle on our back and burn you with electricity. They had a box, and they would wire your legs with wires. So there were all sorts of torture. The way I was beaten up, and they would bring you upstairs, they had handles of hatches, and they also had some batons that resembled police ones. They were iron, and they would use them to hit me. You mentioned candles as well. Can you explain what they would do? They would sit on a chair, light the candle, put it near your back, and then the drops would fall on your skin and burn you. And the witness continued over a hot iron, and he said, a hot iron, do you mean an iron we iron clothes with, such an iron? Yes, an ironing iron. So she was doing something in the room. I didn't see her. She was behind me. And the location, was that upstairs or downstairs? These were upstairs. And because you mentioned both the cowsheds and the upstairs part, what would they do downstairs in the cowshed? What type of mistreatment? Well, whoever opened the door would kick you or slap you. They wouldn't leave you without doing something to you. Statement of 4 October, page 884. Other treatments, it happened downstairs. This happened downstairs. While I was in the basement, I asked for water. I asked them to bring us some water. And then 2 soldiers came to beat me. I was lying on the ground, and in the end, they urinated upon me and said, "Here's water for you." The frequency of the beatings. Question was asked about the frequency. It happened almost every day. Perhaps there was the odd day that I was not beaten that much, so the intensity was less on those days, but I was beaten almost every day. Your Honor, the witness status in the testimony all about this. I would like to move on to the torture.
Defense counsel,
Yes.
it is almost time to conclude today's session. So I propose that we continue tomorrow with your closing statements. Could you give us an indication how much time you think you would need tomorrow?
I'm almost finishing. Maybe 1 hour maximum.
Okay,
Maybe
because
1 hour.
if the calculation I did is that you would have still 40 minutes
Right.
in general, but of course you will be granted time you need it. But so that would be in the first session you could finalize.
Yes, for sure, Your Honor. That's for
Okay.
sure. It's
Because in that way we will organize it in such a way that the SPO and Victims Council will be granted also some time in order to, if necessary, to prepare or to add to comments or prepare comments on things you have said also tomorrow.
yes.
Yeah.
Okay.
Okay.
Your Honor, then.
Sorry, I didn't hear.
Oh, sorry. Yes, no, I think then that would wrap it up for today.
Okay.
It's
Then
obvious.
Okay, I will do that when we finish our hearing. So can we agree on the fact that you will be finishing tomorrow in the first session?
I'm 100% sure,
Yes?
Your Honor.
Okay, good. Then the schedule for tomorrow. We will finalize the closing statements by the defense. Then we have foreseen in our agenda the responses of the SPO and the Victims Council to the points made by the defense and by the point made on the innocence or accused, innocence and guilt of the accused and the sentencing, if any. Then we will have the comments of the defense to the responses of the SPO and the Victims Council. Yeah. We will see if there will be questions by the panel. And at the end of the day, and maybe going into Friday, it just depends how much time everything will take, we will discuss the reparations. Yeah, if any, of course. Good. Then this is it for today. I thank the parties and the participant for their attendance today. I thank the interpreters who've had a really long day. Thank you for that. Our stenographer also, and the people from the audiovisual booth and our security. The hearing is adjourned till tomorrow.
All rise.